Miss Joyce. Miss Joyce.
Would you mind muting yourself, please? Thank you.
Uh-huh. You're welcome. Oh. Okay.
Madam Clerk?
Yes, sir.
Yeah, this is John Goldpaw. I'm just checking in on DeMarcus Lee.
Okay.
Thank
I'm
you.
gonna start marking you guys off so that you don't have to like yell out your names.
Okay, thank you.
Okay, thank you.
didn't even get that far.
Oh, okay.
Division 2. Who do we have in the chair?
Brandon White Ratliff, appearing for Zoom Court.
Ms. Robinson?
Yes, good morning, Judge.
Morning. So I really kind of just set this for a review day because we are, I wasn't even sure if the parties were appearing. You know, because we've already sent this down to court administration for trial.
I'm sorry, someone else's video is, I couldn't hear you, Judge. People aren't muted.
I know, that's fine. Yeah, I need everybody to mute. It's probably the jail though. Mute Mr. White Ratliff again. And mute Division 1 floor for now. Okay. Ms. Robinson, so my question, comment was that this matter is already in court administration awaiting trial scheduling, correct?
That's right, Judge, but there's a new development.
Okay.
There's a hold because he picked up a new case. And for his tether, for your tether, Judge. And we go to court tomorrow in 36th District Court. It's our first hearing probable cause conference. So I would ask the court to allow him to return to his previous status, the bond that this court has already ordered, and that he can be released from the jail. His bond on his new charge is a personal bond, $5,000 personal with tether.
Okay, so let me say this. I had no idea. It's just on here as a review date. And I'll take a closer look at it. What's the charge?
Domestic violence.
That's the new charge, pending charge?
Yes.
I know that. Okay. Right. So the short answer is I'll bring you back next week to address it because I completely had no idea that was the case. So I just thought this was going to be, hey, it's a review. You guys are checking in. All is well. We're awaiting scheduling for trial. So yeah, I'm not making that decision, but I can bring you back. I'm on this docket again next week, and I can address bond at the time after I take a look at the file and see what we're going to do. Okay?
Yes, Judge. What day, please?
I am on this docket again on the 5th. And I gotta grab my, hold on, I know, 1 second.
Thank you.
You mean this?
Yes, ma'am, thank you. All right. August 5th, docket D, like dog, at 1 p.m.
I'll be there.
Thank you. Mr. White Ratliff, we'll see you next week.
Thank you.
No, or I can get it. I know, it's on my desk. You don't have to, because I don't have anybody else waiting. I don't have anybody else in the chair.
Okay.
So I can just step off and get it real quick.
Madam Clerk, who would you like next at Division 2?
Give me 1 second.
No problem.
These are with the divisions that they're in?
Mhm.
Oh, okay.
And Woods and Holt are together, and it looks like they are
No. Wasn't hoping for that.
Oh, no, she's on two different ones. Okay. It can be, you can bring out Mr. Holt.
Yes, ma'am, come right up.
Thank you.
Morning, Madam Clerk.
Good morning.
Do you happen to know who House Counsel is so I can get the warrant over to them?
Thank you, Ms. Petty. It's me.
Okay.
I was looking at them for in the assignments at ndsdetroit.org thing yesterday, but they didn't come through.
Yeah, normally they say they don't receive them. You could put your email in the chat. I'll send it right over to you.
Madam Clerk, can I ask a quick question?
Thank you.
I'm Alex Benson on behalf of Christopher Maynard. He just called me from jail 1 and no one ever came to get him at all, and he has a hearing this morning.
He is on the docket, so they'll probably be coming to get him shortly. We have
Okay.
quite a few in Division 1, so.
No worry.
And Madam Clerk,
Thank you.
I
Yes,
wanted to let you know there. So for the failures to appear, alleged tether violations and alleged violations of probation, Mr. Goldpaw is here. I didn't know he was going to be here, but Mr. Chavez is his client. And so I don't know if that would be something helpful. Ms. Silver is here for someone as well. I think Mr. Cole, if I'm correct. And then Miss Jordan is also here for someone as well.
For Mr. Coon. Thank you.
Yep. So I just have those remaining, I think 3.
You'll have everybody else. Okay.
Good morning. Excuse me, Madam Clerk.
Yes, ma'am.
Hi, this is Stephanie Carson. I'm actually here for Daryl Lindsay.
Thank you.
Thank you.
Oh, I see. I think I see.
Yeah. LaDon Dorch. Okay. Seated in Division 2, can I get your name?
Gary Holt.
Clerk said that he's in 2 of 3 Zooms right now. He's going to Zoom in as soon as possible for getting them.
Okay. It's just the one that you're calling, 696.
Okay.
Okay, because I was. Okay. Parties ready for Gary Holt?
Ready.
Calling case 21-000-696-01 FC. People of the state of Michigan versus Gary Holt. This matter is set forth for final conference today. Appearances, please.
Good morning, Your Honor. Ashley Chaffone on behalf of the people, P75922.
Judge, good morning to you and your staff. Lillian Diallo, P52036, on behalf of Gary Holt, who appears on Zoom technology from the Wayne County Jail with consent.
All right, thank you for that. Mr. Holt, good morning. Can you hear me?
Yes, Your Honor.
Okay. All right. So I know that the filed a motion, and Mr. Fong, do you have it?
I do, Judge.
Okay. All right. I assume you need.
She don't disconnect the court.
Yes, Judge, I would be asking for a little bit more time. I can have it filed by Monday morning. So just, I don't need much of a further out date, just a little bit more time.
Yeah, and Judge, in fairness to Ms. Chiffon, because I try to be fair, I did file it a couple of days later than I than I thought I would be able to file it, only because I had to deal with a different issue. So Judge, I can understand her needing a little bit more time, and that's fine. If I can just be put in a breakout room with Mr. Holt after we get the new date, I would appreciate it.
All right, sure, no problem. So, you're actually going to get a little more time than you're asking for because the court is, I mean, just with the schedule, and I have a jury trial and some other things. So let's see when I can bring you back. So you were asking for a week, Ms. Chiffon?
Not even, Judge, but I'll take a week.
All right, and then let's see when we're gonna bring you back, actually.
If you want,
So if you end by the 3rd,
buy them up, and then when they.
the week, the 9th is bad for the court. So let's see. So let's see where you are in terms of your return.
Robert.
Oh, Judge, actually, I just to remind you, we were here the last time, not Miss Diallo and I. I can't remember who is counsel.
Barrett.
Yep, Miss Barrett. Yep. And I think that at the last date, Judge, you said you wanted to try to catch those two up by setting them on the same date. I just need 1 minute, and I can tell you what the other date is. Actually, if that ends up working for Miss Diallo, it's Monday, August 16th was the next date for that.
That's a good day.
Yeah, let's go for that. That's fine.
Okay.
At 9 o'clock, docket A.
Thank you.
However, I mean, I do want to say this. I don't know if I'm going to continue to hold off on the CCW case because logistically it may become, a bit of a problem because we do have the 2 attorneys, which is fine. I don't have an issue with that, but we'll see. I don't know how much of an incentive that really even is at some point, considering, what Mr. Holt's primary charge is. And so, and even if, I don't know, I just don't know if it makes much sense for the CCW case to continue to languish when, if he's in fact going to go to trial on the homicide case, I mean, he's in custody, but as you know, already started back jury trials, but it's starting with the oldest in custody. So I'm just saying right now, but we'll see what happens on the, 16th. I just don't know that I'm going to continue to hold the CCW case because I don't know really, other than taking up space on this court's docket and continuing to be over time standards, that it really makes a whole lot of sense to do that from the court's perspective. So.
My only thing on that, Judge, would just be that I would, and I don't know this to be true or not, but I would anticipate that if Miss Diallo and I went to trial on the homicide case, that likely, regardless of the outcome of the homicide, I think that the CCW would likely resolve itself one way or another anyway. So if it did languish a bit, I doubt that, depending on the outcome, and I don't know this exactly to be true, but I would suspect that if we did the homicide trial, that would end up falling into place one way or another.
I don't disagree. I'm just saying in the meantime, I have another case that's just sitting there and nothing done with it for however long. That's all I'm saying.
Yep.
So, but again, I just want to put that out there in full transparency. I haven't made a final decision, but I just wanted to let you know. Okay.
Thank you, Judge.
Thank you. So will it be the 16th in the morning?
Yes, ma'am. Docket A 9.
I got you. Thank you so much. And if I can go into a breakout room with Mr. Hall, I'd appreciate it.
So, Rochelle, move Ms. Diallo and Mr. Holt, who is in Division 2, to a breakout room.
Yes, Judge.
Thank you, Judge, and thank you, Ms. Diallo.
Take care. No problem.
And Judge, I am also here on Mr. Woods, but I'm going to stay on the line.
Okay. Thank
Thank you.
Division 1.
They're muted. Division 1 Explorer. They're muted.
On our end or their end?
I asked them to unmute, Judge.
Morning, Your Honor. I don't know if you heard me or not, but I have your tether violators, violation of probations, failure to appears. It's Mr. Menard, Cole, Khan, Killigan, Howe, Lindsay, and Chavez.
Maybe give me Maynard first.
Okay. Okay, I'll send them right in.
Your Honor, this is Wyatt Harrison. I didn't hear Letitia Young name mentioned in that Division 1 matter. Is she up for today?
She is on the docket today.
Okay,
I'll follow up with him when he comes back.
thank you.
All right, no problem. And are you covering for Mr. Slough? I think that's his name.
No, I'm retained counsel, Alex Benson, Your Honor.
Okay.
And he's on who?
Maynard. For Maynard.
So he's on this, okay, gotcha. This is both cases in that one file.
Yeah.
Good morning. I am returning a missed call from this number. You can call me.
Is that Mr. Maynard in the chair? Division 1 8th floor. What's your name, sir?
That's Mr. Maynard.
Okay. Well, Mr. Maynard, can you hear me?
Barely, but yes, I can hear you.
Hold on one second. Ms. Haney, what matter are you here on?
For Chad Haney, I'm the mother of the victim.
Oh, okay. All right.
And Your Honor, this is Madeline Jennings, P44692. I'm here today representing Chad Haney for his competency hearing.
Got it. Okay. Thank you.
That's going to be have to be moved today because I spoke to the forensic center and they said he won't even be seen until the end of August, Your Honor.
Okay. We will, we'll probably put it on the record, so I'll get him as soon as possible.
Okay, thank you, Your Honor, because I have another court. Thank you.
All right. Ready on there.
Calling cases 184782 and 213519. People of the state of Michigan versus Christopher Maynard. These matters are set forth for a violation hearing and a calendar conference. Appearances, please.
Good morning,
Alex
Your Honor.
Ben-
Joelle Huishi for the people, P82089.
Good morning, Your Honor. Alex Benson, retained counsel on behalf of Mr. Maynard.
All right.
Good morning, Your Honor.
Oh, I'm sorry, Agent Petty, go ahead.
Sorry. Good morning, Your Honor. Leslie Petty, Department of Corrections.
All right. And Mr. Maynard, good morning. Can you hear me?
Yes, I can hear you, Your Honor.
All right. You are appearing today remotely via Zoom. I'll confirm you're okay with that instead of being present in the courtroom.
Yes, Your Honor.
All right. And so I think the first thing the court has to do is recall the warrant. Do you show that in the system, Madam Clerk? Do you?
Yep.
Okay. Okay. All right. So the court will recall the warrant. Mr. Maynard was ordered to turn himself in on June 23rd, following the last court hearing by 9 a.m. And he didn't do that, so the court did sign a warrant, and he was picked up. So the court is now recalling that warrant, so that is no longer in the system. Thank you. All right. So I guess we'll start with the people. Is there anything you want to add? And then I will address, I'll hear from the people, I'll hear from Agent Petty, I'll hear from the defense, and then I'll just advise the parties as to where the court stands as it relates to the people's offer. So is there anything, Ms. Alhuishi, you want to say?
Judge, the offer is still the same, and I can reiterate it here for Mr. Maynard. It's for him to plead to counts 1, 3, and 4 with a sentence agreement of 2 years probation, the first 30 days Wayne County Jail, and a substance abuse evaluation and treatment. I've communicated that to his new lawyer, Mr. Benson.
All right. Agent Petty, do you have an update at all from the probation perspective?
Thank you, Your Honor. As far as the last arrest that was previously stated on the record, there is no pending matter in that. So we just recommend that the case continue to track.
All right. Mr. Benson.
Good morning, Your Honor. I was recently retained, and as the court likely knows, it's very difficult to communicate or have meaningful meetings with my client in Division 1. What I'm hoping is the court considers the following. My client had completed over 4 years of probation on the prior charges for which he was on probation before he picked up this new charge. Well, I in no way minimize the serious nature of the new charge because it is serious. The violation was something distinctly different from what he was on probation for. And in theory, he had not continued in the conduct giving rise to the violation, rather the charges and what occurred to him 5 years ago or 4.5 years ago. What I'm hoping the court will consider is releasing him on at least a tether so that I can meet with him in my office and evaluate, number one, the offer being made. Number two, the violation and how to proceed on that. And it very well may be a plea on the violation. But he's essentially been incarcerated on the violation since June. He had completed over 4 years of the probation. He's not hiding from the charges in any way. He has a full-time job as a auto repair mechanic. He has family in the area. I just want to be able to communicate with him to represent him properly.
So, I know you're new to the case, and I made this thorough record. It sounds as if you're saying that he, with the exception of this case, he didn't have other issues, and that's not the case. He has a lengthy history of violations, and he has like 12 active warrants, or at least 11 active now. The court, whereas I know that's not what parties like to hear, but I ordered him to turn himself into the Wayne County Jail following our last hearing, and I told your client was advised that I would check and see if that was in fact done, and if it wasn't done, the consequences. That wasn't done. I mean, I never like making these decisions, but so the answer is no. You have a couple of options here, and I'll give you some time to, because I know that it's not easy to meet with your client in the jail in this climate that we're in. So I'm not holding that against you, but if he accepts the offer, because I just believe in being candid and upfront, he'll be found in violation of probation. So just so he's clear, and then, and if he doesn't wish to accept the offer, which he absolutely, that is his prerogative one way or another, then we just have a violation hearing. So you decide, hearing that, how you wish to proceed. Because, I mean, the offer proposed by the people, the people, they do what they do and they make the offers, but I know his record and what it's been, while on probation. So I just believe in being upfront, and I know you want to meet with your client. I'm going to give you some time so you'll have your options and see how you wish to proceed.
Your Honor, do you think that I could go to a breakout room with the prosecutor for a little bit and have a conversation with her?
Well,
Your Honor, Mr. Benson, I'm the courtroom prosecutor, so that's not going to be really feasible during today's docket, but we can talk this afternoon.
Yeah, that was my only reservation. I was trying to see if somebody else was ready, but it probably would be too hard to maneuver. But yeah, if you all can talk, and then again, see how you wish to proceed. Mr. Benson, come back. How much time are you asking for?
Very short. We could come back, Monday, Tuesday, Your Honor.
Okay, so I have limited docket availability. So my next day on this docket is going to be Thursday, August 5th at 1 o'clock.
And there's be nothing before then?
No.
Okay, not tomorrow or anything?
No.
Okay. All right, well then that's what we'll have to do, Your Honor.
Okay.
Will we receive a new notice or just put it in our calendars, and I'll reach out to the prosecutor later today?
Yeah, you just put it on your calendar.
Okay, next Thursday at 10 o'clock.
No.
Rather 9 o'clock. I apologize.
No, it's docket D like dog at 1 p.m.
Oh, next Thursday at 1 p.m. Okay.
Yep. Mm-hmm.
Thank you, Your Honor. Appreciate your time this morning.
No problem. Bye-bye. Oh, and then we'll continue to track the probation matter.
Thank you, Your Honor.
Your Honor, who would you like to see next?
Who else do have, let's see. You have Mr. Cole?
Okay, I'll send him right now.
Down a little bit. Stay down a little bit.
Okay. Division 2, 7th floor. What's your name, sir? I need him unmuted again so I can see who that is.
Judge, that is Tyler Cole.
Oh, that is, okay, so Division 1, 8th floor. Who is that?
Yes, Division 1, 8th floor is Mr. Cole.
That's what I thought. So Division 2, 7th floor. I just want to see who we're calling next. Who is that in the chair?
Now that I can't answer.
Rochelle, unmute.
I did ask them, Judge.
All right. Division 2, 7th floor. What's your name, sir? Division 2, 7th floor. Can you hear me, sir? Okay, we'll come back to him. Mute him again, please. Okay, I thought I saw the prosecutor on call. Do we have the prosecutor?
It's yes, I saw her here, Judge. It's Erin Wilmoth.
Yeah.
Here, Judge.
All right, we're ready on call.
Calling case 214585, people of the state of Michigan versus Tyler Cole. This matter set forth for a tether violation today. Appearances, please.
Good morning, Your Honor. Erin Wilmoth, P82085, appearing on behalf of the people.
And Gabby Silver on behalf of Mr. Cole.
All right, and let's unmute Mr. Cole for the moment. Very loud there, but. You sent it, right, Rochelle?
I did, Judge.
All right, I know it can take up to. Mr. Cole?
Yes.
Okay, Mr. Cole, you are appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Yeah, that's fine. Can I speak with my lawyer real quick though?
Not right now. Not right now. We have a lot to get through. Mr. Cole, can you speak?
Repeat that?
Mr. Cole, go
What's going on with the connection?
Mr. Cole, go get the deputy.
He's right here. I just waved him down. I don't know. I can barely hear what they're saying. I don't know what's going on. They keep breaking up. I can't even hear what anybody's saying.
Your Honor, did you need Mr. Cole?
I need Mr. Cole, but I cannot have this hearing with all the noise. I mean, I know it's somewhat challenging, but he needs to be able to somewhat hear what we're saying.
Okay.
If you can let him know.
I'll move it to a doc or a tablet. Just take me 1 second.
Okay, for Mr. Mayor, are we doing a continuation of violation hearing?
No, you can make that a pre-trial.
The calendar conference?
Yeah. While we're waiting, unmute Division 2 again. I need to figure out who's in the chair, so I know who we're calling next. Rochelle, make me the co-host so I can do this too.
Okay.
All right.
Okay. Okay.
I think that's much better. Thanks. Well, I don't want to speak too soon, but okay. So we're people of the state of Michigan versus Tyler Cole. So, Mr. Cole, can you hear me?
Yes, I can.
Okay, very good. So, Mr. Cole, my question was, you are appearing today via Zoom. I'm confirming you're okay with that instead of being present in court.
That's fine.
Okay, all right. So we have multiple things to go over as it relates to Cole. We have the question. Let's mute Mr. Cole and then we'll answer him if and when we need him. Okay. All right. So we have multiple issues to address as it relates to Mr. Cole. We have the people's motion to revoke bond. We have an arraignment on a tether violation, and then we have Ms. Silver's motion to withdraw as counsel. So in terms of order, let's start with the people's motion to revoke bond. Madam Prosecutor.
Yes, Judge, the people did file this motion as we laid out in the motion, which I trust that the court has read. While out on bond, a tether bond in the present case, which involves criminal sexual conduct charges for an 8-year-old 11-year-old, and 17-year-old. So 3 complaining witnesses. 2 of those charges are criminal sexual conduct in the first degree, which carry a mandatory minimum of 25 years. They're very serious charges. While out on bond for this case, on his tether, last weekend, he was picked up and arrested for another criminal sexual conduct allegation, this time involving a 26-year-old female. There was no delay in disclosure. This 26-year-old called 911 right away. This is very concerning to the people that while out on bond for criminal sexual conduct charges that are very serious in nature, that now here we are with new criminal sexual conduct allegations. So certainly this tether is not very helpful in protecting the public from Mr. Cole's impulsive behavior towards criminal sexual conduct. So we are asking to revoke his bond at this time.
Okay. Also, so Ms. Silver, so I heard you. I'll see how Ms. Silver wants to respond, but I also want to just state for the record, the court is in receipt of correspondence from Ms. Silver, and it's dated Monday, July 6th at 2:50 p.m. And the correspondence, I thought I asked for him.
Mr. Cole, you need to mute your tablets.
Okay. All right. So correspondence again from Ms. Silver, counsel for Mr. Cole. The court is in receipt. It's dated Monday, July 26, 2021 at 2:50 p.m. And in sum, Ms. Silver indicates that she was representing Mr. Cole on the matters that have now come before this court. Mr. Cole had not been before this court yet. The case had been pending for close to a year in Allen Park District Court and was again just waived over to this court last week. Ms. Silver indicates as part of her representation, a number of letters were submitted to the district court for review for bond consideration based on Mr. Cole's health. The letters were faxed to the court from the defendant's family, and based upon those records, the district court granted Mr. Cole a personal bond with a tether. Ms. Silver asked the court to withdraw those letters from consideration, as it is her understanding currently that the letters submitted to the court were not authored by the person named in the letters. Ms. Silver, thank you for that communication. Is there anything more that you need to say? The court is in receipt of the letters and has reviewed them. So I guess go ahead.
Yes, Judge. I take my oath as an attorney very seriously. And when I learned that Mr. Cole had violated the conditions of his tether, I reached out to the place that I believed had been managing Mr. Cole's medical care. As I indicated, those letters were not submitted by me to the court. They did come from a place called Unified Michigan, which I did confirm on Monday is an actual place that manages patient care. I did receive a phone call from somebody who claimed to be the name on the letter, Kelly Gajaldum. I was attempting to locate Mr. Cole. She indicated to me that she did not write those letters. So I felt that it was my obligation to notify the court that I wish to withdraw those letters from any consideration as it relates to Mr. Cole's bond, because I learned that they were fraudulent. I then sent an email to Kelly Gajaldum I sent her the 2 letters that had been submitted to the court I wanted written confirmation from her. And they did go to Michigan Unified or unifiedmichigan.org. However, I have not received a response back from her. I tried to call her and tried to call Unified Michigan again, and I received no response. So I am basing my representation to the court on what information I learned from the person who was supposed to be Kelly Gejeldum on Monday, who advised me that the letters were false. She had not written them.
Okay.
Beyond that, she couldn't give me any information because I did not have a release of medical information from Mr. Cole for her. I had one from the University of Michigan where Mr. Cole had some medical treatment. However, I did not have one from her. So I did not want to, I actually contacted the state of Michigan Bar Ethics Hotline and an attorney to inquire how to proceed. And this is what I was advised to do. So it causes me great concern. And that's why I took the step I took. I will also tell the court, Mr. Cole doesn't know this because I couldn't get a visit with him since he's been locked up. So that's where I am, Judge.
Okay. All right. Mr. Cole, is there anything you wish to say?
Yes, Your Honor. I was unaware. My dad was taking care of all those letters for me. I was unaware of anything. I was told they came from Unified. I'm unaware of anything. When I got picked up on this case, when I got picked up on the new case, they said I caught another case while out on tether. I received a personal bond on that case. I was on my way to heart surgery. I've already had one of my surgeries. I'm scheduled. I'm on IV antibiotics. I'm in the hospital. I'm on an IV port. I'm on a PICC line. I can show you all the scars. I'm due to be back in University of Michigan this afternoon. I'm due to be back in Cleveland Clinic first thing Tuesday morning. I mean, I'm just worried about my health, Governor. I'm in pain. I tried to talk to the jail here. They're unable to give me a majority of my medications. Since I've been incarcerated, I haven't been on any of my antibiotics. I am HIV positive. I've been unable to get any of my HIV meds. I'm unable to go to any of my care. I'm unable to receive any of the antibiotics for my heart. I'm not on my Coumadin, so therefore I'm non-therapeutic on my blood thinner. They believe I have the beginning of another DVT. I understand everything everybody else is saying, but I mean, my main concern is I was tethered to an address and was doing my best to take care of my medical. That's all I really care about. That's all I'm worried about. I want to live. I don't want to die in jail because of something that I can't control. Now, as far as proof, if the court needs proof, all I would have to do is get out. I can give you whatever letter you want signed by my doctor you need. I have no problem with that. I just have to get into the office. I talked to my tether officer. I sent him over some information about my upcoming appointments. He told me to put a release of information on file, so in case if anything like this ever happened, the court would be able to contact. I never made it in to be able to file a release of information. That's something I could look into. I'm in extreme pain. I can't sleep. The infection's getting worse. I have orange, yellow pus oozing from, I don't know if you can see, but I have orange, yellow pus oozing from the sore where they cut me open. Stuff's bad, really bad.
Okay, so
Your Honor, may I say a couple things to address what Mr. Cole just said? First, I want to say I absolutely appreciate Ms. Silver's candor. We have been in discussion about this. We both share the concern, same trouble and concern, and have been communicating. I also called Unified Michigan, left a message for a gentleman that answered the phone and was told that the individual who, was represented to have authored these letters would call me back, and I have not received a call back. But what's more is when Mr. Cole was arrested on these new criminal sexual conduct charges, he made some of these assertions to the officers at the Detroit Detention Center that he had this heart surgery and chest pains, and they took him to St. John's Hospital. That report was provided to Ms. Silver. At St. John's Hospital, they evaluated him, they did a chest x-ray, and he was medically cleared. And what's more is Mr. Cole wants to represent to the court that he will send information about upcoming appointments and his condition. Well, how are we supposed to trust anything that he sends to the court? Look at the position he already put his court and his own attorney in with these falsified documents. Quite frankly, the people don't believe we can trust anything that he says at this point.
Your Honor, can I say something?
Briefly.
Oh, okay, so yes, they did take me to St. John. And if you really read that report, yes, I was medically cleared. But then Saturday or Monday morning, when I went in front of the judge at 36th District, he contacted University of Michigan himself. He contacted my doctor that was supposed to do my procedure himself. And he felt that it was necessary to give me a personal bond because I was supposed to be in University of Michigan Monday afternoon. They rescheduled me for Friday because I had to come face my tether violation. The judge at 36 contacted University of Michigan. We went on a whole recess. He called University of Michigan, validated my appointment, validated everything I had said, and at that point felt that it was okay, necessary to give me a personal bond on the new case. If you look, I am out on a $50,000 personal bond for the new case, and I go back to court for it, I believe the 16th or the 17th in front of Judge King.
So here's the problem. What the district court does is what the district court does, and the district court, what's the alleged new charge? That's the CSC 4? Is that, Madam Prosecutor? Is that what that is?
Two counts of criminal sexual conduct in the 4th degree under the incapacitated victim portion of the statute.
Right,
Because
okay.
the complainant was alleged to have been asleep and woke up to Mr. Cole allegedly removing her nightgown, trying to remove her bra, and touching her vagina and her breasts. So she was in a vulnerable position. He's absolutely a danger to the community.
And so what I was getting at is that that's a CSC 4, and again, the district court judge does what he does, but that's different from what the court has in front of it right now, which 2 counts of CSC 1, 1 count of CSC 2, 1 count of CSC and unlawful imprisonment. So this court is very much concerned with your well-being, absolutely, but I cannot endanger everyone else as a result. I mean, I've looked at these. Sorry, I'm talking now. Let's mute Mr. Cole.
I'm sorry.
All right, because the first letter says that I see that that you have an appointment on July 16th, 2021, and that you have this, very major surgery, and basically that the results could be, the consequences could be severe if you don't have it, if he fails to make this appointment, again, that it's potentially life-threatening. And then to find out that this letter was not authored by the person whose name is on it. I mean, I don't know what you want me to do. And then there's a second letter. So initially, it says the procedure was scheduled for July 16th at 8:45 a.m. And then it says you're scheduled for a court procedure on July 20th, 2021. But you have surgery, you have a court date at the same time, so you can't make the court date because you have the surgery. So first it was scheduled on the 16th, and then it has you scheduled for the 20th, and then you pick up a new case, CSC on the 23rd. I mean, I honestly, again, I am very concerned, but I cannot verify anything that you're saying at this point.
Your Honor,
Yeah, go ahead.
Hold on, Judge.
hold on.
I didn't think he was muted. I could still hear him.
Okay, I'm gonna ask the court this, and I'm gonna pray nobody thinks I'm stepping outside of bounds, or I'm saying anything that I shouldn't be saying. I know Ms. Silvers might say something. Give me 24 hours. Grant me a bond. Give me 5 hours. I will have signed documentation from AMD. I'll sign a release. The court can talk to whoever they want to. I can go to U of M today. When I get it, I'm due to be at U of M by 5 o'clock this afternoon. I can have whoever you want to. Call the court directly, call Ms. Silver directly, call the prosecutor directly. Give me 5 hours out on tether, Your Honor. And I'll prove to you that everything I've said is correct. Now, I've already gotten my dad's ass about those letters. My understanding was that he had something worked out with Ms. G and with Kelly at Unified, and they were working on that themselves. When I became aware, when my dad said something to me last night, I wish you could hear the recorded jail call that I cussed him out and told him you pretty much just ruined my life. My medical is my #1 concern. Yes, I'm concerned for everybody else. Yes, I understand everything else everybody is saying. I'm asking for 5 hours, Your Honor. You'll have me on GPS tether. I can't go anywhere. For the next 2 weeks, I will be mandated to University of Michigan. I'm at the part of my procedure where there will be no more coming home. At first, it was the first procedure, then I went home for a week, and I take antibiotics at home, I'm on a PICC line at home, I heal up a little bit, then I come back in. For the next 2 weeks, it'll be straight University of Michigan intensive care cardiac. If you can give me the chance to get out to make that appointment, I can give you whatever proof you want. I just can't do it from in jail. They won't let me sign a release from in jail.
Okay, so but the problem is that doesn't address the you were already out on tether. What you're asking the court to do at this point is trust you and your work. And I don't know how I do that in these circumstances.
You're right.
No, stop. What I'm going to do, I'm going to reach out to jail manager, evaluate it, and see if they're back to the hospital. That's as far as I'm prepared to go. And I can see what else we can do behind the scenes to get some verification. But, I mean, based upon the people's representation, and you didn't dispute it, was that you were taken to St. John's and that you were cleared, coupled with I have absolutely nothing to substantiate. All I have is capital charges out on tether because of falsified medical documents submitted to the court, and then I have new charges, CSC related charges. So based upon that, bond is revoked. You'll stay at remand, but and so I've arraigned you on the tether violation. I am going to grant Ms. Silver's motion to withdraw as counsel.
That judge, he doesn't know about that either. So, because I mailed it to him in the jail, but I'm sure he didn't get it yet. So if we could just make a record, please, so we can be clear on all this.
Yeah, okay. So, after Ms. Silver sent the letter to the court, asking the court not to consider those medical records, the letters that were submitted regarding Mr. Cole's medical condition, that she found out that they were not written by the author. Ms. Silver also filed a motion to withdraw as counsel. So Ms. Silver, is there anything else? I've already read.
Yes, Judge, I filed a motion to withdraw as counsel. I cannot, I feel like Mr. Cole has put my bar ticket at risk, frankly, and I can't trust anything Mr. Cole says, and there has clearly been a breakdown in the attorney-client relationship, at least from my end. I can't continue to represent somebody under these circumstances. He has been appointed counsel on his new case. They tried to appoint me. I rejected the appointment. So I don't know if she's on the capital list, but perhaps she could take Mr. Cole's other matter too. I'm happy to turn over the discovery to anybody who the court appoints to represent him.
Okay, so the court again has a motion and we'll grant the motion to withdraw. We'll send a communication to this board to have, you were appointed, right, Ms. Silver?
I certainly was, Judge.
Okay, so we will have new counsel appointed for him. We'll figure out who that's going to be. In the meantime, again, I am going to put in my order to have him evaluated by medical, and I actually am going to follow up off the record just to make sure that this does not fall through the cracks. Because again, I'm concerned with this, you know, what he's stating to be his medical condition. I don't think he's fabricating a condition.
Your Honor, can I just ask one question?
No, not right now. No. But again, I can't trust anything that he submitted and anything that he says. And if he was in such dire strait and needed this procedure to basically save his life, I should have got a tether report that he's picked up new criminal sexual conduct charges. So again, I just can't do what Mr. Cole is asking me to do. So bond is, again, is set at remand, but again, I am going to follow up with jail medical and see if there's a need to get him to the hospital. Again, that's the best I can do with what I have. I have to think about Mr. Cole and his well-being, but I also have to think about everybody else. All right, is there anything else for the record from the people?
Nothing from the people. Thank you, Judge.
All right, anything else for Ms. Silver?
No, Judge, thank you very much.
All right, okay.
Your Honor, can I just ask one question?
Go ahead, Mr. Cole.
Okay, so if I can get the court some medical records from U of M and get some documentation from my doctor, if I can find a way to get a release signed from inside county, would the court be willing to address bond at another date to go to these appointments? Or are we just basically saying no?
I'm going to bring you back anyway, probably to see if you have new counsel. I don't know. I'll have to see what the options are. I mean, there's a way if you need to have saving surgery that you can have it and still be in police custody. So, and so you would have it and then potentially come back. I'm not there yet because you're saying all of these ifs and I don't have those in front of me. I'm just telling you what I'm prepared to do today once I get off this record. We're not going to keep talking about it. So let's see where you're at.
Judge, I do just have a question. Do I have the contact information for Mr. Cole?
I'm sorry?
I said, do I have the contact information for Mr. Cole?
I don't understand your question.
For new counsel, because I'm going to have to send the request for new counsel.
If I could just say that the lawyer that's been appointed for him for his new case is Sally Irwin.
Oh, okay. Okay, thank you.
Thank you very much, Judge.
All right, thank you. Don't go anywhere, Madam Prosecutor. Mr. Cole, how many do I have on this?
11 so far.
Oh, okay. So I'm gonna, Mr. Cole, he works for the people, just to make sure he has new counsel. Docket D, 1 p.m.
Your Honor, my apologies. You froze up for a minute there. I think it was our internet connection. Could you repeat that date?
I'm sorry, it's August 5th, D.
August 5th, docket D. That is great.
August 5th, that's 1 week from today at 1 p.m. Again, in the meantime, I am going to put in my order that he be evaluated by medical staff. And again, I'll have a follow-up conversation to say, to see if he needs to be conveyed back to the hospital. He indicated that he was in some pain. So again, I will take care of that on the court's end.
Thank you, Judge. I'll see you next week.
All right, thank you. All right, Mr. Cole, thank you. Right. So I need an order. Okay. Division 2, 7th floor. What's your name, sir? I don't understand what's going on.
It's like the judge real low.
Sir, what is your
Yes.
name? What's your name,
Damian
sir?
Bates. Damian Bates.
Okay, all right. Are the parties ready on Bates?
Ready, Your Honor.
Okay. We're ready on Bates.
Calling case 213351, people of the state of Michigan versus Damian Bates. This matter set forth for final conference today. Appearances, please.
Good morning, Your Honor. May it please this most honorable court, Danielle Seamus on behalf of the people, P75908. And Your Honor, I see Ms. Joseph on, but I believe she's still muted. I did send her a text, Your Honor, to let her know they're calling the case, but she hasn't yet responded.
Okay. Oh, I see. Yeah, I don't know what you're doing. Division 1, tablet. What's your name, sir? What's your name, sir?
Stephen Coon.
All right.
I'm gonna put your name in there. That way your attorney will see it. Oh, they did?
Kearney, are you handling, Mr. Kearney, are you handling Mr. Coon or is he?
No, it's Miss Jordan.
Yes, that's my case, Your Honor.
Okay, all right. Do you need to
I couldn't hear you.
you need to speak to him in a breakout room?
I do.
Okay, so Rochelle, move Mr. Jordan and Mr. Coon, who is the division staff, to breakout. Oh, okay.
Okay, it's 313.
Okay, I muted. Ms. Joseph, can you hear me?
Yes.
Mr. Harris, mute your microphone. Thank you. right, Mr. Bates, can you get the deputy for me?
Sir, the judge, your honor, asked me to grab you.
Yes, Judge, I'm here.
Who else do you have? You don't have Mr. Bates's lawyer. She's not ready. She's in the picture, but I think it's in another. Okay.
Judge, I have DeMarcus Lee, Andre Woods, and Daryl Ewing.
Lee, Woods, and then Ewing.
Yes, ma'am.
All right.
Your Honor,
Yes.
Judge, before they bring over Lee, can you and Mr. Goldpaw and I step into virtual chambers before he's called?
Yeah. Okay. Rochelle, move the court. Ms. Alhawashi and Mr. Goldpaw.
Yes, Judge.
are you with us?
Yes, I am, Your Honor.
Okay, all right, so Ms. Chaffone,
Yes, Judge.
is Mr. here? I thought
I'm not sure I heard that, Judge.
is Mr. Cripps here?
I'm not sure. I'll text him right now, though.
Because if not, then I take Ewing. So, yeah.
I had down that it may have been set for 11. I wasn't sure, but it still shows up as always at 9. So I'll text him right now. But if it was 11, I anticipate that it might be because he had something this morning. But I'll reach out.
Then I'll just take Lee, then I'll take Ewing, and then we'll see where we're at with him.
That might be best, Judge.
Okay, that's what
Thank
we'll
you.
do. All right, let's call Lee.
Calling case 21-000-245, people of the state of Michigan versus DeMarcus Lee. This matter is set forth for pretrial today. Appearances, please.
Morning, Your Honor. Joelle Huishi for the people.
Your Honor, John Goldpaw, P. 30758 on behalf of Mr. Lee. Your Honor, may I step back and turn down another computer so it doesn't interfere with ours?
Yeah.
Thank you, Your Honor. Again, John Goldpaw, P. 30758 on behalf of Mr. Lee.
All right. Mr. Lee, can you hear me?
Yes, ma'am.
Mr. Lee, you are appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Yes, ma'am.
All right, so let me, let's just say we have a couple of things here. Let's start first with, we have the defense's motion to quash. The underlying issue is, there was a question regarding Mr. Lee's representation on a couple of occasions for this court that he was incarcerated on the date of the alleged home invasion, which is the subject of this case before the court. So, Ms. Ahueshi, is there something that you wanted to say in that regard?
Judge, first of all, I'd like to make a record. I have Sergeant Larry Dickey here that I'd like to place under oath to answer some questions so that there is a record made with respect to this allegation that Mr. Lee has continuously put forward before this court. So if we could do that, I'd appreciate it with respect to his incarceration status on the date of this alleged crime.
Okay, yeah, where's Sergeant Dickey? Oh, I see him. Okay, Sergeant Dickey, good morning. Can you hear me?
Yes, Your Honor. Good morning.
All right, right hand. Do you swear or affirm the testimony you're going to give the court will be true?
I do.
Okay, thank you. You can put your hand down. Ms. Ahueshi.
Sergeant, yes, Judge. Sergeant Dickey, how are you employed?
Sergeant with the Wayne County Sheriff's Office, currently assigned to the
Currently assigned to the what? You cut off.
tether unit.
Are you familiar with the person by the name of DeMarcus Lee?
Just from the call I got about his outdate for tether when he left the jail for tether.
Okay, can you tell me what you know about that? Can you, for this record, tell me what you know about with respect to DeMarcus Lee and whether or not he's been incarcerated by the Wayne County Jail, whether or not he was ever placed on a tether and what dates those were?
Yes, he was placed on tether September 21st, 2020 and released from here, according to our records, at approximately 2:15 in the afternoon. And then he was brought back into custody on October 2020 and brought back to Division 1.
And these records that you're relying on, can you describe to me what those are, how those are generated?
It's through our jail management system. And even when you're out on tether, you're still in our custody. So it's going to show custody. You have to go to the housing and it shows electronic monitoring, EMU.
Okay, Judge, that's all I have for him.
Okay, Mr. Goldpaw, do you have any questions?
It's my understanding from your testimony, sir, that on which date was he released on tether?
September 21st of 2020.
And you indicated what time?
At approximately 2:15 in the afternoon.
And it's my understanding that when you're on tether, you're able to track individuals on tether. Is that correct?
That is correct.
And do you have any information on his tether as to what locations he may or may not have gone to on the 21st while he was out on tether?
Not on me, I do not. That would have to be looked up.
Okay. And you didn't do anything by looking anything up for this hearing, is that correct?
Just the date he was released on tether and the date that we brought him back into jail.
Okay. And while he was out on tether, did you have any further contacts with him prior to him being returned for the instant case?
I did not. My officers did.
Okay. And who was your officer?
Deputy or Corporal Christopher Wiskowski.
Okay. And on what date was that, if you recall?
9/28, September 28th of 2020.
You said 9/28
of 2020. Yeah.
Okay.
And Corporal Wiskowski was actually contacted by DPD about him, and that's how the report was generated.
Okay, and I can have one moment, Ron. And do you recall where he was when he was contacted?
I do not. I would have to review the report to see what the circumstance was.
And do you recall when he was incarcerated for these particular matters?
For his original charge?
Yes. For the charge we're now facing in this case. He wasn't on tether for the case we're now addressing. Is that correct?
I'm not sure what his exact tether case was.
Okay. Well, I have no further questions at this time.
Ms. Alhoishi, anything else?
No, Judge.
All right, Sergeant Dickey, thank you for your time.
Thank you.
All right, so let me just say, the court is satisfied based upon the hearing the testimony from Sergeant, also by submitted by the prosecutor that shows there's a printout that shows his status at 9/21/2020 at 14:50 hours, that his status is EMU. And so also again reconciling that inconsistency regarding the letter or terminology, letter of incarceration, hearing Sergeant Dickey explain, under oath that, he's still considered basically in a nutshell in custody of the Wayne County Jail, even though he is out, out in the world per se. Mr. Goldpaw, I just want to state that it really, for this limited purpose, the court was just very concerned because Mr. Lee did say I couldn't have possibly have committed this home invasion because I was in custody. We didn't even get to the point of whether or not that's an issue for trial if we go to trial. So whether the tether showed him there, that has nothing to do with this court's limited purpose. I just wanted some resolution on the issue because if he was incarcerated, I mean, that was, and he's not at remand now, he does have a bond, but I'm saying that was part of the reason of the court not reducing the bond. So again, that line of questioning, we're not there yet. So that's not an issue. The issue, very narrow issue before this court, was he incarcerated in the Wayne County Jail or was he out on a tether? And again, this court is satisfied based upon the proof submitted and the testimony that he was in fact out on a tether. So,
And I agree, Your Honor. The only reason that I raised this was not as part of the motion to quash, but as I've indicated, but because Mr. Lee insisted and presented me with the documentation, which I did send to Ms. Hollowishi, which indicated that proof of incarceration, Mr. DeMarcus Lee, date of birth, etc. And it says subject was booked into the Wayne County Jail and released on the following date. It said 6/11/2020. Release date was 2/9/21.
no, understood. You did what you were supposed to do. And
That's right. I just want to bring that to the court's attention based on what Mr. Lee demanded that I do.
yes, no, absolutely. And so I really don't even need to hear from Mr. Lee. He you know, he's made his representations and the court's made his record. So I think it's best for him that he not say anything else.
I don't disagree with that, Your Honor.
All right. And so as it pertains to the motion to quash, what do you want to say?
Well, Your Honor, only that I did file a motion to quash. I know this is a very high standard. My own, there has to be proof that it's probable cause to believe that a crime was committed and that Mr. Lee committed that crime. The only main issue, Your Honor, that I feel that the judge abused her discretion when she found the testimony. First of all, the testimony that was submitted, the testimony of the complainant, Chantel Singleton, she testified, and it's all laid out in my motion, so I'm not going to regurgitate it, so to speak, was that she never saw Mr. Lee at the location. She said that her daughter told her what occurred, and this was admitted under, I believe incorrectly, under the excited utterance. There was no showing that there was any excited utterance. This is particularly true when you hear the testimony of the daughter, and I'm hoping I'm pronouncing her name correctly, Jamra Singleton Chase, where she testified, and she is the only individual who testified that she saw Mr. Lee come to the home. She testified, and it's again laid out in my motion, that Mr. Lee came to the home, entered the home, spent about 6 or 7 minutes, went through an open door, the door wasn't locked or any of those things, and that he came out with one item in his hand. It was a television. He then left the area. She then went back into the home, and when she went into the home, her mother, Miss Chantel Singleton, was in the home. That is the only evidence that should have been admitted, and it doesn't show any breaking and entering. It does not show anything except that he was in the home, presumably with permission, because according to the testimony of Miss Chase, Miss Singleton was in the home. The court, in its findings at page 45 of the exam transcript, at page, not its findings, the court itself, the exam transcript, asked this question of Miss Chase. So are you saying your mother was in the house when he came into the house? And the response was yes. That's on page 41, lines 4 and 5. Your Honor, then the judge goes on to find there might be some confusion. There is no testimony on this record that there was any confusion. There was no testimony on this record that Miss Chase didn't know what she was saying. And in fact, she contradicts the testimony from the mother. So I would suggest that in doing so, Your Honor, credibility can always be taken into account. There's no showing that she was not credible. I did not do the exam, so I can't, follow up on any of those questions. However, Your Honor, I would submit that there has been an abuse of discretion and that there was insufficient evidence to show that Mr. Lee committed the crimes as charged.
If there was inconsistent testimony between the two, why would both be relevant and why wouldn't both be a question of, on the point of whether the mother was home or not? I think that's what you raised. Why wouldn't both be relevant, and why wouldn't both be, why wouldn't it just be a question of fact for the fact finder?
Because, Your Honor, of the circumstances in which the testimony came in. And I say that only because the first witness to testify was Miss Singleton. Miss Singleton said what her daughter said, did all those things. There was an objection to the hearsay nature of that testimony. It was admitted because there was a claim of excited utterance. When Miss Chase testified, there was no evidence of, number one, that the conversation between Miss Singleton and Miss Chase, her daughter, even occurred under those circumstances. There was no testimony from Miss Chase about any other individuals, only the information that she observed with Mr. Lee. And the most telling part, Your Honor, is that she says her mother is in the house when she goes in. That's the problem with this, because Miss Singleton testified differently. And she was allowed to testify to the excited utterances because only Miss Chase observed Mr. Lee. That's the reasons why, Your Honor.
Ms. Alhoishi.
Judge, I don't have anything to add in addition to my written response.
All right. So the court finds that the people have met their burden to a probable cause standard. The district court judge sums it up quite well in this court's opinion. We have the testimony from Jamira Singleton Chase. She's a young child. She's 11. And again, I'm surmising that, what the district court said. She was, and agree with what the district court said. She was pretty clear. She knows Mr. Lee. She said she testified that she saw him enter the home and leave with possessions that were once in the home, put them in a car and drove away. There's testimony from Chantel Singleton, who's the mother, who has a child in common with the defendant, and she testified that she did not give the defendant permission to enter her home and remove any items as it relates to the inadmissible, the claim of inadmissible hearsay. I'm not certain that that's the case based upon the testimony, because and I know, Mr. Goldfarb, you weren't representing Mr. Lee at the time, but when the hearsay objection comes up, the court says, do you want to voir dire? And then defense counsel says no. So at that point, I don't think it's just crazy just how it was even presented, that it just is not an excited utterance. And then when he declines to voir dire, I don't know what you'd have me do at that point. But again, I don't think it really even comes down to that, because Jamira testified and she was subject to cross-examination. So we don't just have the mother's statement. We do have Jamira testifying under oath, subject to cross-examination, which is typically the issue with hearsay, and by hearsay is being inadmissible and unreliable, which subject to the exception. So, which is why it's not typically allowed in our court, because you can't test the reliability, and that's not what we're dealing with here. We have the court finds that you have probable cause based upon her statements under oath. Again, subject to examination, that's enough. And even if there were, our case law tells us that oftentimes it is just harmless error, especially at the exam stage. But again, I don't even think we need to go down that path based upon the record already made. As it relates to the credibility issue, the district court judge made that call. She did not find the testimony to be incredible, and she did note, that any inconsistencies is for the trier of fact, to weigh and consider. So the motion to quash is denied for the reasons stated on the record. So as it stands right now, are we moving towards trial? If so, we can talk about motions and limine cutoff, jury instructions, and submission of witnesses. What are we doing here? Mr. Goldfarb?
Oh, I'm sorry, Your Honor. Your Honor, I would suggest if we could, if I could get into, I know I can't do it today, if we could I'd like to speak to the prosecutor regarding a resolution. There has been an offer made. We were working this all out. Would the court consider a final pretrial and then see if we're trial ready if necessary?
Yeah, Madam Prosecutor, place the offer on the record, the current offer, and I know he wants to talk to you again, but yeah, give us the offer.
Yes, Judge, the offer is for Mr. Lee to plead guilty to count 1 with a sentence of 1 to 15 years at the Michigan Department of Corrections. We would withdraw the habitual 4th offense notice.
All right, so Mr. Goldfarb, you have that. I can bring you back in a couple of weeks because I think this is a 21 case, if I'm not mistaken. Yeah, it's a 21 case. So I'll bring you back one more time before I give you motion and limine cutoff. Okay? So how about the 23rd? Well, maybe the 16th even, to see what your status is. So the 16th, if that works for you, Mr. Goldpaw, docket A.
Docket A, I'm sorry, you said the 16th?
August 16th, Monday, August 16th, docket A at 9.
Let me just check my calendar. I need a second here.
No problem.
That'll be fine, Your Honor. I have a live exam that day. It's in 36th District Court, but that's at 11 a.m. So that'll be fine, Your Honor.
Okay. Remind me when I see you. You should be done, but just remind me on that day, okay?
I'm sorry, Your Honor.
Just remind me. You should be fine with the timing, but just remind me, okay?
Oh, I will, Your Honor. Thank you.
Okay. All right, thank you. Mr. Lee, you're all set. We'll see
Your
you.
Honor, can you put Mr. Lee and I into a breakout room?
Yep, I can.
Thank you.
Mr. Lee, I see you. Put your hand down. Put your hand down, Mr. Lee. Yeah, Mr. Goldpaw, I will put you in a breakout room with Mr. Lee, but let me unmute him first.
Excuse me, may I say something on the record, Your Honor?
No.
No.
No, it's not about my case. It's not about my case or nothing like that. I was just asking, I'm saying like, I want to discuss my bond if we could one more time.
We're not discussing bond, Mr. Lee.
I'm saying, wait, listen, just hear me out. Your Honor, you said that they said that when I got out, that I went and did something. I'm saying, can you hear me out, please, Your Honor, please? Please.
No. Mr. Lee, I have heard you out multiple times. You have represented to this court multiple times. The fact that you were in or out doesn't even matter and doesn't even go to whether or not you would have committed the crime, but you represented to the court that you were in custody and you could have been out and could be completely not guilty. I've listened to that. I've listened to you talk every single time. I've actually, given you a bond that this court actually thinks is reasonable. I have a heavy docket. I'm not addressing it today. Again, I'm going to move you to a breakout room with your lawyer. That is it for today. Rochelle, move Mr. Lee and Mr. Goldpaw to a breakout room.
Thank you, Your Honor.
All right.
Judge, did you want me to put them in a breakout room?
Correct.
Okay, just a moment.
Well, you know what? No. Hold on one second. I can't, Mr. Paul, because I need whoever's next, so I cannot do it today. I cannot, because I have a lot of people still left. And so it's 11. Yeah, and it's 11 o'clock, and I have to be off at 1. So yeah, sorry. Mr. Lee, you're all set. Get the deputy, please.
Mr. Lee, give me a call tomorrow or the next day. Thank you, Your Honor.
All right, Mr. Goldpaw, thank you.
Yes, Judge. Who would you like next? Mr. Ewing?
Yeah, bring Ewing, please. Thank you.
Okay.
Judge,
No
and
problem.
Ms. Joseph is also back for Mr. Bates.
Okay. Well, we'll do Ewing because I know, yeah, we'll do Ewing. And then Ms. Jordan, you're back, right?
Yes, Your Honor.
Okay. And you're here on, is it Coon? Remind me.
Yes, Stephen Coon.
And is that who we have in the chair?
Yes, ma'am.
Okay, all right. So we're gonna do Ewing followed by Coon. Everybody ready? No, we don't. Oh, here. Okay. Here.
Calling case 101495, defendant 2, people of the state of Michigan versus Daryl Ewing. This matter is set forth for final conference today. Appearances, please.
Good morning, Your Honor. Cam Towns, Assistant Prosecutor on behalf of the people. My P number is 45518. I am joined on part of this motion by the Chief of the Appellate Division, John Votala.
And good morning, Your Honor. John Voitala for the people, P number 49474.
All right.
Good morning, Your Honor. Coral Watt appearing on behalf of Mr. Ewing, and I believe Ms. Diallo is here.
That is correct. Lillian Diallo, P52036, also appearing as co-counsel for Darrell Ewing. And good morning to you, Judge, and your staff.
All right, Mr. Ewing, good morning. Can you hear me?
Yes, good morning.
All right, Mr. Ewing, you are appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Yes, ma'am.
All right, so just a couple of things. First, if it hasn't been entered, it will be entered, but there's a signed order from the presiding judge regarding Ms. Diallo as co-counsel for Mr. Ewing. I know the presiding judge approved it previously, but everybody swapped around here. So I have actually received the order and I gave it to our, I don't know, Madam Clerk, do you have it yet? I don't have any. Okay, that's okay. My law clerk has it and it'll be entered today in that regard.
And I appreciate that, Judge. That will alleviate the problem I've had with trying to e-file. It will not let me e-file. It kept kicking me out in this particular case because I could not make an appearance. So thank you so very much.
Okay. All right. So yeah, that's no issue. Where are we on the discovery issue?
Judge, I think that maybe Mr. Kearney should be involved in this as well because we filed a protective order for discovery on Mr. Ewing and Mr. Searcy. And I think that today was the day when Your Honor was going to make a decision on the protective order that the people have requested in this matter.
Let me ask you this. Did you file? I didn't see it. Did you file a motion?
Judge, yes, I filed a motion and Mr. Kearney responded to it.
I thought, okay, so, and that goes back to doesn't work without a hitch. I saw your motion. I thought Mr. Kearney and Ms. Diallo were just responding based upon just kind of your oral representations. And I thought that they were just kind of being proactive in responding. When did you file your motion?
Judge, I had a colleague of mine file it for me through the e-filing system. I can pull that up on my phone. Yeah, she sent me a copy of the e-filing, and it was a request for the court to sign the protective order.
What's the date of the e-filing? Well, let me ask this, Ms. Diallo. Ms. Diallo wouldn't have gotten it because she wasn't.
No, Judge, they treated me badly in this case, but that's why last night, as a last resort, I just emailed it to everybody, and I promise you I'll e-file as soon as they let me e-file.
No, that's fine. Ms. Watt, do you have it?
did receive a copy of her motion. Yes, Your Honor, and I believe I forwarded it to Ms. Diallo because she was going to file the response. And that was a couple weeks ago, I believe, if I'm correct.
Judge, there was dates that were set that you were very specific about when the motions had to be filed. And so I'm looking at my calendar to figure out when those dates were. But Ms. Watt, you did receive the motion that I filed.
Yes.
Okay.
I got it too, Ms. Towns.
Okay.
Judge, and if I may, it might be because it might have been filed under Mr. Searcy, and his case isn't up until next week.
But it doesn't matter. We've gotten the alert, right?
Right, but when I printed it off for Mr. Searcy's date because that's the name that's listed on it.
Oh, so we did.
And that's what I saw.
Yes.
That's what I saw.
Judge. So I have it printed out for Mr. Searcy's date, which is dated for next week.
Right. It did say Searcy.
Okay. Hold on one second. And what was the date? Right. I don't know. I'm trying to get to Rachel, come here for a second. Is this the motion to compel one? No. That's what I'm saying. I literally, because I check e-files every morning too. Just stand by. I mean, it sounds like everybody did what they were supposed to do.
I have it for 8/5 because that was Mr. Searcy's date.
Right.
Oh, you have, okay.
Hold on. This is the opposition to people's motion.
Then I don't have that. That was all that I have. I don't have the people's motion.
Right. We have Mr. Kearney's response. So again, I thought that Mr. Kearney was just being proactive and just filing.
I don't see it
the same thing. I don't see where we ever, because I was looking for it all along because I did give specific dates. So.
Ms. Watt,
It may have been served on Tina.
I'm sorry.
Are you able to see, Ms. Watt, when you received the e-filing? Because again, Tina Ripley, APA Tina Ripley filed it on my behalf.
I don't disbelieve you at all. I'm just trying to figure out where we went wrong here because it could have been filed under Tina, my prior law clerk, who's not here anymore. But I still look at e-filings every morning as well.
Wait a minute.
Judge, unfortunately, right now, I can't get into the Odyssey system. It shows the system is being down, so I can't give you the date on that.
No, hold on. That's fine. My clerk.
I'm trying to find it and I don't see it.
Mr. Kearney, are you able to indicate what date you received the e-filing?
So this is what I have. It was on the 16th. It's a motion to compel to file application for.
I'm looking right now, but I'm also like driving, so that's not super safe.
Oh,
Give me a
that's
minute, I'll be ready.
Probably not a good idea.
Can't find it for some reason. I'm going through my emails. I don't know.
I don't see.
Judge, if I could pause, I'm going to contact Ms. Ripley, the person who filed it on my behalf, and see if she could forward something to me with a date. If I could be excused for a moment, Judge.
Or at this point, just send it to the court because everybody's in agreement that you did file it. I've never received notification of it because again, in addition to my law clerk, I get them as well. And I check every morning. So
Okay, Judge. I'm going to contact her right now.
Okay, no problem.
Thank you.
And I think the problem is going to be it went in under Dorico Searcy only. So there is no docket entry for Mr. Ewing. And it
that's
says,
right.
Yep, it says Michigan, state of Michigan versus Searcy. So I'm pulling up that filing. It looks as if it was I don't know what this is, Judge. Let me see.
I said, yeah, so you can stop looking for it. I don't think you're gonna find it.
Yeah,
get it. We can
I have an order, the protective order dissolved.
It was in after that.
I know what happened.
Now,
It looks like it was e-file 630, but it only went in under Mr. Searcy. You can see both of their names, but it was not precipied separately.
Okay.
I don't know how that happened.
It might need to be filed 2 times. That's the only thing I can think of for each.
Judge, I did find it in
defendant.
Odyssey.
Okay. Yeah.
It's filed under a miscellaneous, that's why.
Yeah, that's
Problem too, I guess. Okay.
you need me to print this one?
Yes, please. All right, so having said that, I'm not prepared to rule on it because I need to go back and look and see, because I did request that the people actually indicate what they're looking to protect and the
I have to go now. Could you send it to her? Thank you. Bye-bye.
We have it this time. It was filed under miscellaneous. I think maybe the disconnect. Because
Thank you, Judge.
I received it, so we're all set.
Okay.
I'm going to, I gotta get Mr. Ewing and Mr. Searcy back on the same day anyway. Mr. Searcy, NBOC did not have any times available today, and the only other date was tomorrow, and I don't even have a docket tomorrow. Mr. Searcy is up due to come back on the 5th, but I remember that date wasn't good for
me, Your Honor. I'm going to be out of the country from the 2nd to the 11th.
Okay. All right.
Which is-
Okay. So we can put it, I can put Mr. Ewing over for the 5th, and I can rule if Ms. Diallo can just cover it, or I can just do it when we have Ms. Watt back. So.
Which would you prefer, Ms. Diallo?
Judge, I indicated last time we were here that I was going to be out of the office from Thursday, the 5th, returning on Tuesday, the 10th.
Okay.
And for what it's worth, Blaze Kearney will also be out on the 5th. Miss Robinson is going to be covering for me, so I don't know if it might make sense to push it further.
Okay. So how about the 16th is your next one? Yeah, the 16th, August 16th,
That's fine with the people, Judge.
9 o'clock.
Can we do it a little later?
Yeah, I mean, everybody 9 o'clock on this emergency docket, so you just come when you can.
Okay, thank you, Your Honor.
And both the defendants will be together at that point, Your Honor?
Both of them, so I'm still bringing Mr. Searcy back on the 5th, as scheduled, because I didn't, I don't want to prolong the issue and
Right.
out a motion. And then again, both defendants will be here on the 16th.
Yes.
Okay. All right.
Thank you, Your Honor.
Judge, I asked Mr. Votala to appear to answer Mr. Kearney's motion on the writ issue. Does the court want to entertain that argument today?
Well, I don't think we really need to, so I'll just tip my hand and say where I am on it. And I'll repeat it again for, I guess, the record on next week when we have Mr. Searcy here. At the end of the day, I don't know, I think everyone, because everyone's so intelligent, we were being a little really super specific, I guess, or I mean, at the end of the day, the court has no issue with issuing a writ to bring Mr. Searcy here. So the court was not refusing to do that. The way I understood the course of events was more so, well, with the people, can request the court to do it. And then the people's response was, no, we don't issue writs. And I think, like Mr. Kearney was saying, it's not that you would issue the writs, but you could ask the court. I've looked into it, and it's pretty standard that it's my understanding that I can writ Mr. Searcy out. We could talk about that some more on the 5th, Mr. Kearney, to see actually the timing of it. Do I think he'll be able to stay until trial? No, but we could writ him out. I know that you have definitely, I think he should be here and needs to be here based upon especially the limitations with MDOC in terms of assisting with his defense. So again, that's a non-issue. So I don't think we need to take really time. I'm even willing to rid him, and then if he has to go back, then we can bring him back again. However, but I'm here to make sure that everybody gets what they need to represent their respective parties competently and effectively. So we don't need to discuss every issue anymore. The court will issue the writ, and we will talk about the timing, Mr. Kearney, because MDOC may need some notice, and I don't want to writ him, and then he comes, and 1 week is eaten up because you're on vacation. So we'll talk about that next week. Well,
Judge,
Understood. Thank you.
Judge, you keep saying the 5th when Mr. Searcy's here on the 5th. I'm going to be out of the office from the 5th until the 10th. I thought the next time we'd all be together is on the 16th.
Okay, so that's what we're gonna have to do. You did say that. So let me say this. Everything is so challenging around here. Mr. Ewing was scheduled for the 29th. Mr. Searcy was scheduled for the 5th due to some entry error. Then I tried to bring them both today. MDOC couldn't accommodate. So long story short, since Ms. Towns was going to be out on the 5th, then on the 16th is when we will have them both. And since I know Mr. was going to have Ms. Robinson stand in, but if Ms. Towns can't be here, then that's fine.
Understood, Judge. Yeah, and our only issue is that we just want, if the court's going to issue the writ and Mr. Searcy will be here in Wayne County on the 16th, then we don't have an issue with that. It's just, we wanted to get that issue heard. But I hear what the court's saying. So if the court's going to issue the writ, we don't need the 5th date.
Yeah, I will issue the writ. I just don't know. I don't see why it wouldn't be enough notice, but I just don't know. But I will issue the writ. Don't worry about the 5th. And then the court will rule on this motion for protective order on the 16th. And again, hopefully
Understood.
We'll have both defendants here and hopefully both from the Wayne County Jail. Okay?
Awesome. Thank you.
Thank you, Judge, for the time you spent on this case thus far. Thank you.
Thank you, Your Honor.
Thank you.
Thank you. Mr.
Okay, I'll
Matala.
see everybody now that I'm legitimate, Judge, as the lawyer. You'll be getting my filing forthwith. I was gonna ask the prosecutor, the appeal attorney, how to help me. He wouldn't mind helping me. All right, everybody.
I don't know if that
Thank
makes you legitimate, Ms. Diallo, but glad to have you aboard.
Way more legitimate than you. Everybody take care. Bye-bye.
Bye-bye. Take care.
All right.
Judge, would you like Mr. Wuss or Bates next at Division 2? Those are my last two. You said Bates?
Yes.
Okay, come right up.
But we have Mr. Kuhn in the chair. Let's call Kuhn.
Calling case 214973. People of the state of Michigan versus Stephen Kuhn. This matter set forth for a motion hearing today. Appearances, please.
Joe Alhuishi for the people, Your Honor.
And good morning, Your Honor. Rachel Jordan on behalf of Stephen Kuhn, P76222. He is present by Zoom.
All right, thank you, Mr. Kuhn. You are appearing today remotely via Zoom. I'm confirming you are okay with that instead of being present in the courtroom.
Yes, ma'am.
Okay, all right. Okay, so let's see. I mean, our clerk indicated it's a motion hearing, and I think they have to. But this is, this is an arraignment on a tether violation. So according to the report I have in front of me, Mr. Kuhn is on a bond for stolen property. His bond was $5,000 cash, 10% with GPS tether. And it is alleged that he violated the tether. He was supposed to treatment at team wellness, but long story short, for what I'm reading, that he did not do that. He absconded from team wellness, and he was actually located and as a result of a strap tamper. And so again, there's the allegation that he was supposed to go for treatment at team wellness, didn't do that, and then allegation of a strap tamper. So Ms. Jordan.
Your Honor, just by way of clarification, we were in court on the 27th at the district court, and the bond was modified to 5,000 personal bond with the GPS tether, and there was no condition for him to go to Team Wellness or any treatment center. He was supposed to go home. I just wanted to make that clear for the record. And I think that's probably where all this fell apart and led to some confusion. But as to the arraignment, we would stand mute.
Okay, all right, and this is Judge Deborah Thomas's case, because yeah, that's what I see here. I mean, I don't know. So, Ms. Jordan, you're saying that that was never even a condition?
Correct. I'm assuming, because it all happened on the same day, I'm assuming that the bond conditions weren't updated in the system. And maybe they were just putting him on the original, out on the original bond to treatment center like they do some of the other clients.
Okay.
But that was never discussed at the district court.
Okay, hold on one second.
Okay.
All right, so Ms. Jordan, it is, I don't assume we have the prosecutor here. Do we have a prosecutor here?
Judge, I'm here. I'm filling in for the tether violations.
Okay. Because it looks just from based on what I can see that this, he doesn't even see Judge Thomas until the 3rd. He's scheduled to see her.
Correct.
And this is the bond conditions from the district court. Is that right, Ms. Jordan?
Yes, it was a personal bond.
Okay, so I'm trying to understand, where did this come from about Team Wellness and him absconding?
That I am not sure.
Okay, and then there's the issue with the strap tamper. So it's, again, the allegation, the strap tamper, and according to Tether, had lacerations on it. Like there was an attempt to have it removed. And allegedly the employees at Lowe's indicated that he was attempting to cut off his tether. Okay. All right, Ms. Alhawashi, do you have any insight on this Team Wellness component of it?
Judge, I don't. I originally was just going to say that we let the APA of record in Judge Thomas's courtroom on the 3rd address that, because I don't have this file. I don't have that background. And if Ms. Jordan is representing that that wasn't a condition of his district court bond, I can't speak to why this report would have been generated.
Right, but the tether was a condition, right, Ms. Jordan?
Correct.
So that's my issue. So Ms. Alhawashi, for him to see Judge Thomas on the 3rd would mean that based upon the allegations in the tether, you know, is that he tried to cut the tether off.
Yes, Judge. So with respect to the tether, I mean, clearly the report speaks for itself. I don't know why he would attempt to cut the tether off. Obviously, the charge is not an assaultive charge. I don't know if Your Honor would want to reinstate his bond with the GPS tether, or again, if you would like for Judge Thomas and that APA to address it on the 3rd, if he is to remain remanded until then.
Yeah, the problem is the 3rd is Judge Thomas's out of custody day. So that was only because he was out of custody. When is Judge Thomas's next in custody day? I don't see her on here. I don't see over with.
Unless Your Honor wants to just handle this and reinstate the tether.
Well, the problem is, I mean, I would love to do that, but I mean, I have indications that he's taking the tether off, then that just makes it, you know, kind of moot. I mean, on the 16th at 1 p.m. Yeah, that's the problem. She's not back until the 16th. What's his history? I know this is just stolen property.
Yes. Let's see. He is a habitual 4th offender. Don't believe he's on probation or parole at this time. So, I mean, he is working. He was supposed to go back home so that he could continue to provide for his mother and his daughter so that they won't get evicted.
Okay, so what's the response to the allegation that he was attempting to cut off the tether and that there are cut marks on the tether here?
And Your Honor, he's not contesting that. He would, if necessary, plead guilty to that.
So if he can't wear the tether, I don't know what you want me to do. I mean, he doesn't get to decide I'm not gonna wear the tether. And I know I'm just preaching to the choir, Ms. Jordan, but you know, that's probably part of the reason why he got the personal bond. So we could try again with the tether, but I'm not confident that's gonna work. I mean, he is a habitual 4, but I'm not gonna reinstate that prior bond. I'm gonna give him an opportunity to get out. I don't want him to necessarily, I mean, if it was a closer turnaround,
right.
But Judge Thomas, go ahead.
And even if Your Honor were willing to do like a low cash bond, I would ask for that.
I guess I do want some clarity on this teen wellness issue as well. So I'm gonna pass this matter because if it's the strap and teen wellness, he's probably gonna sit. If it's just the strap, I probably just will adjust his bond and we'll go from there. So I need to understand more. Ms. Ahawashi, I don't know if you have the ability to try to contact that prosecutor or no.
Judge, I can try. I'm not certain that I'll be able to get a response before this morning's docket's over.
Okay.
The prosecutor was Megan Matthews at the district court.
Okay. All right. We'll try. And so I'm going to pass the matter for now, and then we'll see what we can find out. Because I don't understand how all of that information will be put in that report if it's not accurate. But stranger things have happened. So we'll see who we're at. All right. We have. So Division 1. Okay, we have Killigan in the chair now. Let's call Mr. Killigan.
Calling cases 203380 and 21.
Judge, I don't know if the case was called. There was a lot of background from the facility.
Hey, Mr. Killigan, go ahead and mute yourself unless they're gonna talk. There should be a little button to hit a mic option.
What do I gotta do? What do I gotta press? Leave?
The mute button. Don't hit the leave button. And just unmute it if you got it when it's your turn to talk. All right.
Good morning, everyone. Just to let everybody know, the court is experiencing some technical difficulties at the moment. I am working on them and we'll get Judge back in just a moment, okay?
Just press it.
Okay. So let's call. Okay, let's call Killian.
Calling case 203380 and 21806. People of the state of Michigan versus Ian Killigan. These matters are set forth for tether violations today. Appearances, please.
Still Alhuishi for the people, Your Honor.
Blaise Kearney from the Neighborhood Defender Service of Detroit, P83960 on behalf of Mr. Killigan, who is appearing via Zoom from Division 1.
All right, Mr. Killigan, you can hear me, right?
Yes, ma'am.
All right, so you are appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom?
Absolutely.
Okay, all right. So again, this is an arraignment on a tether violation. Says on March 3rd, Mr. Killigan was enrolled in the tether program. It is alleged.
Sorry, I'm having a hard time hearing the court, and I don't have the document you're reading from, so.
Oh, you don't have the tether report?
No, the sheriff doesn't send us any of the tether violation allegations.
Okay.
Would you like me to send this to him, Judge?
Yes.
Thank you.
My apologies, Mr. Kearney.
No one's fault. It's the sheriff's fault. That's whose fault it is. But not anyone that's currently present at the sheriff's department, because they're sheriff's office, because they're the ones who get me the interviews with the clients at 7 in the morning. So I'm cool. I'm cool with those guys.
Mr. Kearney, I just sent that over to you.
Thank you. Oh, there's no actual documents. There's just these one-liners.
So that's the first time that's ever happened. It's usually an actual official report.
Yeah, I've seen them before. All right, well, we'll work with what we have.
Yeah. I knew coming into it, it was going to be one of those days, so it's lived up to the hype.
This does reflect to what I had discussed with Mr. Killigan earlier today and what I believe the violations to be, so I'm prepared to go forward.
Okay, all right. Okay, so just in a nutshell, from what I could see, he's released $5,000 personal with GPS tether house arrest, and it is alleged he violated the tether because due to the fact that there was a warrant for failure to appear out of 25th District Court. The warrant was issued into lien on July 12th. It is noted that he was not in violation of the house arrest requirement. So, Mr. Kearney?
Yes, Judge. We would ask the court to reinstate the tether condition. I would note for the court, Mr. Killigan has a couple of cases here that he's here for a tether violation, and he had a couple of cases in Lincoln Park. The failure to appear when you have that number of things going, sometimes they slip your mind. But he went out to Lincoln Park. He was otherwise in compliance with his tether condition. It was only that failure to appear warrant. The judge in Lincoln Park gave him a personal bond as well. So he is currently this tether violation allegation is the only thing holding him. So we would ask the court to admonish him that he needs to pay better attention to all of his court dates and keep those in the air, so he doesn't miss any of them, especially in the era of Zoom when things can change on a moment's notice. So that he has to have a proactive obligation, but otherwise to reinstate his tether condition in the underlying case, in these cases.
Yeah, I mean, based upon what I see here, I mean, if I just saw he was in violation of the house arrest, but it's noted that he was not in violation, and I'm not sure. Yeah, he doesn't have an excuse for not being there because of the fact that he can appear on Zoom, but due to the fact that he only received a personal bond I am willing in this instance to reinstate the bond conditions again. And he already has a post, $30,000, 10%.
Yeah.
I see $30,000, 10%, and then I see $15,000, 10%.
Yeah.
Can you shed some light on that, Mr. Kearney?
Yes, those are both true. He's already posted both of those, so we'd ask that being reinstated.
Okay. No, I was just reading, but then on the tether report, it says $5,000 personal.
That, I believe that's the Lincoln Park case, Judge. That's what Judge Clifton and Lincoln Park have imposed. Because he also is put on a tether in that case as well. So he now has 3 tethers, well, 1 tether for 3 cases.
Okay. All right. Ms. Alhowashi, do you have anything you want to say?
I have no objection to defense's request.
Okay. All right. So yeah, I mean, again, based upon what I see here, the court is going to, and based upon the action that the district court took, the court has no issue with reinstating the prior bond. So, I mean, Mr. Killigan, I mean, it is very important, and it's, you know, it's what your lawyer said. These are your dates. You have to keep up with them, and you have to call in. It's not even like you have to go. So. I mean,
Yes, Your Honor. I'm not making, I don't want to make an excuse. The only reason I even didn't think about Lincoln Park was because my court case is down here. Judge Clifford of Lincoln Park said he wasn't going to deal with me until my stuff down here was taken care of. So it was the furthest thing from my mind because I knew I still had to deal with my, I'll keep better track of my court dates though. Thank you.
All right. And like I said, you've already posted and you have been abiding by the house arrest. So other than that, like I said, I just admonish you because next time, if this happens again, you know, the result will likely be, okay?
Yes, ma'am. Thank you very much. Have a good day.
You too.
Thank you, Mr. Kearney.
You're welcome.
So 30, 10% with a tether on one bond, and then 15, 10% on the other.
Yeah.
Mr. Killigan, yeah, he has his hand up here.
Those are already paid, right? They're not going to hit, I don't have to pay those again, right?
Right, yeah, no.
But I have to put it that I'm reinstating that bond. So.
Thank you.
All right.
Yeah, thank you very much.
Division 1, oh, that's Mr. Howell. Okay. Mr. Howell, is this you or someone else? Mr. Kearney.
Mr. Howell, I did not interview this morning. Or Mr. Howe, I did. Gregory Howe?
Oh, yeah, okay.
Oh, sorry, I thought I heard Howell.
Yeah, that probably did say that. So.
Your Honor, I'm sorry for the delay. This is Rita Jones, case manager for Third Circuit Adult Drug Court regarding Mr. Gregory John Howe.
Yeah. Okay. I do see this. Okay. All right. Mr. Kearney, do you have this report?
Nope.
Okay, we'll forward it to you.
Thank you. And I don't know if Mr. Goldpaw is still around. He was actually the sentencing lawyer for this case, or the lawyer who was there for sentencing.
All right, and we also, Ms. Joseph is here. Let's recall. Ms. Joseph, remind me, your client is
Damian Bates. Thank you, Judge.
He's in the chair, so let's recall Bates, and then I'll call Howe momentarily.
Thank you, Your Honor.
No problem.
Recalling case 213351, people of the state of Michigan versus Damian Bates. This matter set forth for final conference today. Appearances, please.
Good morning, Your Honor. May it please this most honorable court, Danielle Seamus on behalf of the people, P75908.
And good morning, Your Honor. Christina Joseph, P79668, appearing with and on behalf of Damian Bates, who is present over Zoom.
All right, Mr. Bates. Good morning, Mr. Bates. Can you hear me?
Yes, ma'am.
Very good. Mr. Bates, you are appearing today remotely. I'm confirming you're okay with that instead of being present in the courtroom.
Pardon me?
I'm confirming you are okay with appearing remotely instead of being present in the courtroom.
Yes, ma'am.
Thank you. All right. So, Madam Prosecutor, where are we in this case?
Your Honor, at this point in time, I believe we're still waiting on reports for competency and criminal responsibility. I did touch base with Ms. Joseph this morning. Neither of us have received reports from the referral that was made last time before this court. I don't believe that Mr. Bates has been interviewed, but Ms. Joseph can certainly correct me if that's wrong.
And Judge, that is an accurate statement. We are also still waiting on transcripts from the preliminary examinations that were held in this case. There were 2 dates that were held, and I know those transcripts were ordered, and I can see in Odyssey that the court did sign an order for them, but I have not yet received those either.
All right. So I'll just give you a return date and we'll see where we're at. Those transcripts should have been here because I would have signed them.
Yes, Judge. My notes indicate that they should have been produced some time ago, but I have not received them, and I don't believe the prosecution has either.
That's correct, Your Honor.
Okay, that's fine. Rochelle, make a note to follow up with court reporting on the status of those transcripts.
Yes, Judge.
Okay. So I'll just give you a return date. It's the latest that I have. But it's about a month, so that works out perfectly. If the parties can make it August 30th.
Your Honor,
Go ahead.
that should be good for the people. Your Honor, I will inform the court that at that point in time, I will be on medical leave for about 8 weeks, but I should have coverage for all of my cases during that 8-week time period.
Okay. All right. Thank you.
And Judge, that would be the morning docket, correct?
30th is going to be the afternoon docket.
Okay.
See, like Charles.
Okay, great. Even better. And Judge, I would also like to briefly address bond if the court would allow me.
I'll hear you briefly, but I still have a lot of, I don't have anything in front of me, but go ahead, I'll listen.
Judge, at the last court date, I did request that an updated DSU report be prepared as it relates to bond. I don't know if that report has been prepared, but I did speak with Mr. Bates, and we don't believe that anyone from pretrial services has done any interview with him. His bond is currently set at $0. So if there is not a DSU report, I would be requesting that another one be issued. And I would also be asking that the court set a bond that is not in the amount of $0. He has no prior assaultive or violent criminal history. He has no prior criminal sexual conduct charges, which is the underlying charge in this matter. He does have family ties to the community in Detroit. He would be living with his father, which I have confirmed and spoken with his father that he would be residing there. He is currently disabled and has a number of medical conditions that he requires treatment for that I don't know if the jail is fully capable of providing. He does have a GED and some college education, and he does have employment lined up at Jack's Car Wash if he is to be released. So we would ask the court to set a bond in this case, or in the alternative, order again a DSU report.
So when you say $0, you mean he said at remand?
Yes, Your Honor.
Yes, Judge. Yes.
Okay. And that was what was said at the district court?
Yes, Your Honor. It was set at the
that was-
arraignment on the warrant, and it was confirmed at the district court after a DSU report was issued prior to the preliminary exam.
Okay. And so you're asking for updated DSU report?
Yes, Judge, that's correct.
Okay. Can you see if one was requested?
One.
By me? Okay, so I did request it on the 21st of June. So, but it must have fallen through the cracks. I still request it again.
Okay, thank you, Judge.
All right. And yeah, and I know because it's in the system, but if no one contacted him, then it clearly fell through the cracks. So we will follow up.
Thank you, Judge.
All right, no problem. All right, you're all set, sir.
Thank you, Your Honor.
Thank you, Judge.
We have Mr. Howard.
Let's go, ladies. Well, yeah.
Oh, no, you go.
My car right there.
What?
Yeah.
Yeah. I'll take that.
Okay, sir, I see Mr. Howell is back. I know this is not Mr. Killigan. What's your name, sir? You just sat down. It just says Wayne County Jail, WCJ. Your mask is up under your chin. What's your name?
Charles Chambers.
Okay. Okay. Mr. Kearney, are you handling?
No, I did not interview Mr. Chambers this morning. Or is this Chavis? Sorry. It's Mr. Chavis. I did interview Mr. Chavis this morning.
Okay, but you're handling that, right?
Yes, I am, and I do have the warrant.
Okay. But did you speak to Mr. Howell yet?
I did.
Okay. All right, we're ready on Howell.
Calling case 202202. People of the state of Michigan versus Gregory Howe. This matter is set forth for tether violation. Appearances, please.
Noel Hoishi for the people, Your Honor.
Blaise Carney from the Neighborhood Defender Service of Detroit, P83960, on behalf of Mr. Howe, who appears before the court via Zoom.
Rita Jones, case manager for Mr. Howe.
Okay, thank you. All right, so, sir, you can hear me, right? Oh, he needs to be unmuted.
Yes, I can.
Very good, sir.
Can you hear me?
I can. You are appearing
Okay.
today. You are appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Yes.
Okay, all right. So we are here for an tether violation. According to the report, Mr. Howe is for possession of burglars and B&E, a building, and large B&E, a building with intent. All right, I need to mute.
Mr. There you go.
All right, there you go. All right. And the conditions of release were to he's going to be placed on the GPS tether. Also, the drug program, and according to the report, it is alleged that Mr. Howe walked away from mirrors and then when he was found, during the search, it's alleged that whiskey was found on him, and it's alleged he admitted he walked away. Mr. Kearney, what do you want to say? And then we'll hear from Ms. Jones as well.
Yes, I mean, it sounds like from what Ms. Jones, the fact that Ms. Jones is here is that Mr. Howe is in the drug treatment program or drug court. I think that it is clear whoever wrote this report has an interest in Mr. Howe having his bond report revoked, as it says. They say they reinstated him for the 6th time. They list one date, 2 separate times, one date 3 days earlier. And not to say that like he hasn't had his bond reinstated a number of times, but I think it's pretty obvious what's going on with Mr. Howe is that he has a serious alcohol problem. And he has walked away from treatment and has a GPS tether to enforce him getting treatment. And, thus far it's been unsuccessful. The court knows that obviously knows the scourge of addiction and the way it affects a lot of people that come before the court. The court knows that addiction has been rising and impacts of addiction have been rising throughout the pandemic and the way that it's impacting people. And the thing the court also knows is that, sometimes it isn't the first, second, sixth time that you try treatment that it actually works. That you often have to keep giving people those opportunities so they can get better. The one thing that we know doesn't help people get over their addiction issues is being in the Wayne County Jail. Wayne County Jail has been under a consent decree for more than the last 50 years for failure to provide adequate treatment to people that are currently incarcerated there. And so it is obviously tedious. It is obviously frustrating. It has obviously thus far not been successful to allow Mr. Howe to go to these drug treatment programs, only to have to go pick him up later. But I think that those repeated attempts are going to be what our best shot is to help him get a handle on what's his issue is. I want to point something out to the court. This is a alcohol related problem because Mr. Howe didn't do anything relating to his tether. He walked away from the Mariners Inn with the tether charge and didn't try to take it off. And what did he do? He went to the mire and got a fifth of Fireball. That is not somebody who's trying to deceive the court. That's not the action of somebody who's trying to deceive the court. That's the action of somebody who feels a compulsion to go get drunk. And so my request for the court is obviously like we have this in hand. I think a lot of lawyers and judges we're all very type A people who have gone through a lot of systems, both college and law school and in our careers that reward us when we do things right and punish us when we do things wrong. And it's harder for us to get ourselves out of that mind space into the place where people who have certain issues just have to keep being granted that grace. So that's what I'm asking the court to do for Mr. Howe. Give him another opportunity. Keep encouraging him to do this because really the cycle of going from the Mariners Inn to the mire to the Fireball to getting locked up in the Wayne County Jail, that's the punishment. That's the punishment of him not getting a handle on his alcohol issues, is that he's going to have to keep going through this cycle over and over again. And so that would be my request for the court. And I'm interested to hear what Ms. Jones has to say.
Yes, sir. I appreciate that observation, which is absolutely correct. Mr. Howe did do well his first time at Sheriff McComb. We are requesting, with the court's permission, that he be allowed to return to Sheriff McComb for a period of 180 days to be followed by intensive outpatient treatment, perhaps IOP domicile to be followed by outpatient treatment and recovery services. We do believe that Mr. Howe would benefit from another chance to go back to Sheriff McComb, where he did do very well. We are very confident that with this placement that he will be successful, and it is a longer time than before, but he did well before. We are confident that he will do well again at Sheriff McComb with the GPS tether and perhaps the alcohol tether as well.
So Ms. Jones, let me ask you this, because you have more history than I do, and Mr. Kearney as well. Why was he moved from, why was he at Mariners Inn now as opposed to being at Sheriff McComb?
He went to Sheriff McComb October of 2020. He successfully completed April 20th and was to go to Mariners Inn. He was transported to Mariners Inn by Sheriff McComb personnel. He walked away. At that time, he cut off his tether. He was rearrested, much the same in that situation as this, that he had gone to a store and sold some alcohol. He was sent back to Mariners Inn, this time with the alcohol tether as well as the GPS tether. And this time he walked away. But we do feel that with another chance for him to go to Sheriff McComb for 180 days, that we're confident that he will be successful as he was the first time.
Okay, so I just want to back up. Sheriff McComb and then Mariners Inn, so this was the two-pronged process?
Yes, ma'am.
Okay. So Sheriff McComb was for how many days?
You mean initially or this time?
initially?
Initially, it was from October to April.
Okay.
And he did
And
very
then-
well.
Okay, and then he was supposed to go to Mariners Inn?
Correct. For
Okay,
intensive outpatient treatment domicile.
okay. And then what happened there?
He walked away. At that time, he cut off his tether. He was rearrested on a new charge with alcohol in his possession. He was sent back to Mariners Inn, and this last time he did much the same. He did try to cut off his tether. He had his alcohol tether on him, and much as the attorney stated that he went to a store and stole alcohol once again.
Okay, let me ask this just for clarity, because as it pertains to this incident that's before the court today, is there an attempted cutting of the tether? Because that is listed in the violation for attempted cut, but it's not in the body of this report. What's your understanding as it pertains to not the current issue before the court?
The initial in April was the situation that
Not April, now, the
no, he
recent.
did not try to cut off his tether.
Okay, all right, I hear you. So if this were my case, I know what I would do, but because he does have so much going on here, I want Judge Hathaway to make this decision. She's back on this docket next week, and so he needs to see Judge Hathaway.
Yes, ma'am. We have a drug court status review next Wednesday, August 4th.
Okay, at 9 o'clock?
No, drug court would be at 1:30.
Okay, well, she's on this docket, and I'm keeping him here until she can see him. She's on the emergency docket on August 4th, docket Be Like Boy at 9 a.m.
Okay, that sounds great. Then we can handle him at 9, and then we will have our regular drug court status review at 1 o'clock that same day.
Yeah, I mean, she knows the ins and outs. He clearly has a lengthy history and clearly needs treatment and help. But again, based upon everything I'm hearing, I want Judge Hathaway to make this decision. I think that's the most responsible course for this court to take. So that'll be his next court date before Judge Hathaway.
I appreciate it, Your Honor. Thank you very much.
All right. All right, sir, you're all set.
I need to ask a clarifying question, Judge.
Yeah.
So I'm out from August 4th to the 14th. And this is in the nature of, it came in as a tether violation, but I assume he's on probation to the drug court, right? That's where we're at?
That is correct.
So this would seem to me to be the responsibility of whatever lawyer represents him in the drug court. And do we know who that is? Because I'm not going to be able to be around on the 4th.
Yes, that is Attorney Phyllis Gaydon Robinson.
All right. I will let Ms. Gaydon Robinson know.
Perfect. Thank you, attorney.
Thank you, Your Honor. Thank you, Attorney.
Thank you, Ms. Jones.
Okay. Rochelle, move Mr.
And that's Bridget Hathaway, correct?
Correct, yes.
Thank you.
Move Mr. Chavis and Mr. Kearney to a breakout room.
And my apologies, Judge. Where is Mr. Chavis?
Oh, we're actually fine. We don't need a breakout room, Judge.
Oh, okay. All right.
Yes.
All right.
Calling case 188562, people of the state of Michigan versus Charles Chavis. This matter is set forth for an arraignment on violation of probation. Appearances, please.
Good morning, Your Honor. Leslie Petty, Department of Corrections.
Blaze Kearney from the Neighborhood Defender Service of Detroit, P83960, on behalf of Mr. Chavis, who's appearing via Zoom from Division 1. Mr. Chavis, could you state your name and say that you're okay doing this over Zoom?
Yes, Charles Donald Chavis III. Yeah.
All right, Mr. Chavis, are you you're appearing remotely via Zoom? I'm okay with that instead of being present in the courtroom?
Excuse me?
You're appearing remotely via Zoom?
Yes,
And I'm confirming you're okay with that instead of being present in the courtroom?
yes.
Okay, thank you. All right, so we're here on an alleged violation of probation. According to the warrant, Mr. Chavis is on probation for attempt malicious destruction of fire or police property. It is alleged he violated his probation by, in essence, failing to report and absconding, and also failure to make payments. So, having said that, Agent Petty, do you have any information for the court?
Yeah, yes, Your Honor. Well, actually, I'm not certain how the defendant became in custody. However, at this time, the recommendation is that because he has no pending matters in any jurisdiction, the recommendation is that the defendant's probation is closed without improvement. All outstanding fines and costs to be forwarded to the Department of Treasury.
And Judge, we would ask the court to set aside his costs, understanding that in closing his probation, Mr. Chavis does not have his own home. He doesn't have a steady source of income. And so I think he's indigent and he owes $1,278 to the court. I think passing that on as a lien, or not a lien, a lien against him would be cumbersome to his ability to meet his own needs should he be able to obtain employment. So I think I'm in agreement with Agent Petty. The failure report happened in November of 2020, a couple of months before his probation was set to expire. Probation filed a violation report, and the day before his probation was set to expire, he lost the ability to make a call to probation to a specific officer, lost her number, tried to call probation again over the next couple months, and the main line was no answering machine, no answer. So he fell out of contact. It was his fault for not following up afterward, but he assumed that after January 29th came and went, that he was no longer on probation. That was a wrong assumption of his, obviously, but we're in agreement that probation should be closed. We just asked the court to set aside his costs.
So the court will close the probation without improvement. I'm going to leave the fees because there have been times where, and Mr. Kearney, you've already said it, had he gone back to his agent and asked, hey, what's going on? Can we get these fees waived? I mean, he didn't do that. He got picked up on a warrant. I'm willing to close it out, but I mean, I'm going to leave the fees in place. I mean, they're not, I don't know how aggressive they are with actually collecting them, but if he doesn't have it, he's not being penalized for it. He's not being held, but I mean, just based upon these facts and circumstances, I'm not going to waive the fees.
I understand that, Judge. These kinds of liens, our Attorney General Dana Nessel has specifically spoken out that she's required by law to seek garnishments. For instance, this is the kind of thing, if there was like a stimulus check coming from the federal government, that the court, effectively the Third Circuit Court, would be taking a stimulus check. So while it wouldn't be an imposition on him initially, I think if there's a tax return or anything of that nature where he could be getting a specific refund, it will be going to the court instead of him. I wanted the court to have that information.
No, okay, I appreciate it, but it has to be, some level of responsibility and accountability. He did not fulfill the conditions of the probation. He absconded. Again, we're moving on from that, but I am going to leave the fees, and not to say that under a different set of circumstances that I wouldn't wipe the fees away, but I appreciate that, but the fees are going to stay in place. All right, but Mr. Chavis, you will be getting out. The court will enter an order. Your probation is closed out.
Thank you, Your Honor.
All right, thank you. Okay, Ms. Chaffone.
Hi, Judge.
You were Mr. Cripps?
Yes, Mr. Cripps is on.
Oh, good. Okay, he's on another page. Okay. All right. Division, oh, is that Mr., it's Mr. Lindsay. Mr. Kearney, is Mr. Lindsay your last? I think he is.
Yes.
Have you spoken?
Yes, we've spoken.
Okay. All right. Lindsay?
Calling case 196926, people of the state of Michigan versus Daryl Lindsay. This matter is set forth for an arraignment on failure to appear. Appearances, please.
Good afternoon, Your Honor. Doel Huishi for the people.
And good afternoon, Judge Blaise Kearney from the Neighborhood Defender Service of Detroit, P83960, on behalf of Mr. Lindsay, who's joining us from Division 1.
All right, Mr. Lindsay, good morning. Good afternoon.
Good afternoon.
All right, and you are appearing remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Pardon me?
You're appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Yes.
Okay. All right. So again, this is an arraignment on failure to appear. According to my review of the file, Mr. Lindsay was scheduled for sentencing on January 10th, 2020, and he did not appear. So, Mr. Kearney, is there anything you want to say?
I want to offer an apology on behalf of Mr. Lindsay for his failure to appear.
Excuse me. Excuse me. Mr. Lindsay's my case.
Oh,
excuse me, Your Honor. Mr. Lindsay's my case.
Oh, I thought so. Okay. All right.
I do apologize
That's
for not
okay.
jumping in sooner.
All right. So, Mr. John?
Stephanie Carson standing in for Attorney of Record Ivan Lamb.
Okay.
Good. I was just about to email Mr. Lamb.
Your Honor, Mr. Lindsay did fail to show up for his sentencing in January because he was confused about the date. Then there was a delay because of COVID. However, just recently, he and Attorney Ivan Lamb had reached out to Judge Thomas to turn himself in, and I confirmed with the clerk, Ms. Body, the only reason why it hadn't been done is the judge was on vacation and they had to re-refer him for his PSI. Mr. Lindsay is currently employed at On Point Barbershop. He hasn't had any trouble since he did miss. So what I'm asking the court is to set a bond and allow him to appear before Judge Thomas for sentencing.
Ms. Huishi?
Judge, I have no objection to that based on the charges in this case and based on defense counsel's representations.
Okay. So tell me, Ms. Carson, you indicated you've been in contact with Judge Thomas's
Clerk.
courtroom. He's supposed to
Well, yes, Mr. Land's office, I confirmed that they did try to turn himself in just a couple of weeks ago, but Judge Thomas was on vacation and Ms. Body said he had to be re-referred for an updated PSI. And the only reason why it hasn't been done was because she wasn't able to give a date yet. And she confirmed the judge is out of town on vacation right now. And this was a traffic stop. He didn't get in any trouble. He just told the police who he was at a traffic stop.
Okay. Let's see when. So do you have a appearance before Judge Thomas or no?
Mr. Land does, yes. No, we don't have our date yet. This happened before Judge Thomas returned.
Okay. Let me see. Hold on one second. I'm gonna get you a date.
Thank you.
Initially, I wasn't inclined when I looked at this, just because he was going to serving time according to my review. But I mean, based upon Ms. Carson's representation and the people have no objection, so I will just stand by one moment. I'll get you a date.
Thank you.
Judge Thomas.
Pull up her calendar. Tuesdays, Thursdays.
Well, let me see. Do we know when she's back, Ms. Carson, from vacation?
No, I don't know exactly, but I believe next week would be a good week. Anything after next week.
So I'm gonna put this out. I'm gonna refer him for an updated pre-sentence investigation report.
Thank you.
Then put it on there for 2 weeks.
Thank you.
Well, no, it's gonna be 4 weeks.
Yep,
because
that's
it's
what I
gonna
was
be
getting
out.
ready to say.
Okay.
Maybe the 31st of August, only because the first 2 weeks of August, it looks like she's not gonna be there. Because she's only got like 3, 4, 5 cases max on her days.
Mhm.
She doesn't pick up days until the 17th. She's got 39, 40. So I didn't want to like slam her. So that's why I'm thinking maybe the 31st of August.
That day will work for us, Your Honor.
So, okay. I mean, it's really a month. So it's not-
Yeah.
I think it's extended time. August 31st at what time?
It'll be her regular docket 9.
Okay. August 31st, 9 a.m.
Because that was an out of custody date that you were looking for, right?
Correct.
Yep.
Correct. So the prior bond is reinstated. Sentencing will be scheduled for August 31st, 9 a.m. I'm going to refer him for the pre-sentence investigation report.
Thank you so much, Your Honor.
What was the prior bond condition?
I don't want to mistake, Your Honor. I haven't seen the actual bond document.
That's okay.
He was last at remand.
What was it before remand? Yeah, I'm sorry. Prior to the remand. So.
I have 35%, 35,000, 10% cash or surety.
Okay.
And that was posted.
Okay. All right. Well, I think there's a need to add a tether to be safe. So I'm going to add a GPS tether.
Your Honor, I don't think there's need to add tether. He won't get out for a week in the county with that. I'm going to ask respectfully if the court would not put on a GPS tether, even raise the bond. I think would be better if the court wanted some insurances.
What's the people's position?
Judge, I understand why you would want a tether in this circumstance. I mean, if anything, he's back up on the 31st of August. I'd leave it within your discretion, Judge. I leave it up to you.
What is it again? 35,000?
35,000, 10% cash surety.
Your Honor, Mr. Lindsay never left the home he shares with his mother, where he assists with his younger siblings. He never fled. He's always been here.
All right. We'll leave it at that, only because, again, the nature of the charges, and it doesn't seem like he's gotten into any trouble. And you had already really kind of worked this out with Judge Thomas's courtroom, it sounds like.
Thank you, Your Honor.
All right, because I mean, there's no need in increasing the bond. No, I'm not gonna do that. So we will reinstate the prior bond. Sentencing is on the 31st.
Thank you. You and your staff have a good day.
All right, you too. All right. Let's call Mr. Wood. He's in the chair. Followed by Mr. Harvey. Mr. Lindsay, you're all set.
Calling case 1951993. People of the state of Michigan versus Andre Woods. This matter is set forth for an evidentiary hearing today. Appearances, please.
Good morning, Your Honor. Ashley Chaffone on behalf of the people, P75922.
Good afternoon, Your Honor. David Cripps, P34972, appearing on behalf of Mr. Andre Woods, who's hopefully joined us by Zoom.
He's there. So, Mr. Wood, good afternoon. Let's unmute. Unmute Mr. Wood.
Judge, I'm sorry, who is Mr. Wood? Division 2.
Yeah, Division 2, 7th floor. Mr. Wood?
Yes.
You are appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Yes, Your Honor.
Okay, thank you. All right, so we're really here today. The court has already issued for the evidentiary hearing and relates to the motion to suppress. Mr. Chris, are you prepared to argue your motion to quash today?
Judge, I did file the motion to quash. I would, I guess I could supplement it because I know Mr. Chaffone brought to my attention, I didn't even list in there the officer who I believe was allowed to commit the FOMBI violation. So if the court wanted me to do a supplemental brief, I could.
So that's what I was going to ask you. So because I wasn't clear on who you were talking about.
Right.
So just tell us. I don't need you to file a supplemental brief. I'm not going to rule today because I didn't know what direction, who you were referring to.
Yes,
but
sure.
If you're to argue and just tell us who you're talking about, I don't think that changes substantively, just you inserting who you're talking about. Mr. Fong, do you see that some other way?
I don't, Judge.
Okay, all right. So, Mr. Cripps, if you want to tell us.
Yeah, that would be the officer in charge of the case who testified, of Miss Curry.
Okay. Okay. All right, and so go ahead with your argument. If you want to add something other than what you've already stated, because I don't want you to repeat what I've already read. So do you want to expound upon that?
No, Judge, you wisely read my mind. I was going to repeat what I wrote already, so I won't. But I just supplement the record by saying it's Detroit police officer Desiree, Diasree, Curry, Curry.
Okay, understood. Mr. Phone, is there anything that you want to say now that you know who he's?
Nothing outside of my motion, Judge. Thank you.
All right.
One last thing before we go off the record.
Yeah.
I don't know if the court received it, but my client wrote a motion of his own, which a motion for pretrial release pending trial. I think he sent it with the name Judge Michael Hathaway on it. He's asked that be filed, so I'll file it on his behalf.
Okay. All right. So you filed that. I'm going to bring you back because it's time to start gearing towards trial, because regardless of what happens in this motion to quash, it's only relative to a narrow issue. So I'm going to give you a return date. I need witness lists to be filed. I need jury instructions. I hope to send this case to court administration when I bring you back the next time. Mr. Woods is one of my older cases, definitely. So, Mr. Cripps, a lot of motions have been filed, Mr. Phone, on behalf of the people as well. So this is just the final go back and look and see if there are any motions in limine that you're going to file for this case. Okay?
Yes.
All right. August 30th.
That would work for the people, Judge.
It does, Mr. Bone?
Yes. Judge, is that the date? And it kind of cut out for me. On the 30th, did you want the final witness list, jury instructions, and the trial readiness? Or you said after that date?
No, that's the date that I plan. I would hope to send this case to court administration. Yeah.
Okay, I thought so, Judge.
Jury instructions, witness list. And I'm going to rule on this motion as well, now that I know who Mr. Cripps is referring to, as well as I'll give you about 3 weeks for your motions in limine. Again, a lot's been filed here, so just make sure that there's nothing else that you need to file. So,
Judge, I just have one question.
yeah, Mr. Cripps.
Which docket will that be on?
Oh, I'm sorry, docket C like Charles at 1 p.m.
I have an evidentiary hearing in front of Judge Thomas Hathaway at noon. I'll do that quickly and then come to your docket.
Yeah, and really, you know how this goes. I'll be on this docket for a few hours, so that's fine. You just
Thank you, Honor.
Just come when you're done. Is 3 weeks enough time for you all to file any motions in limine? I think
Yes.
you guys case inside and out. Okay.
Yes, Your Honor.
Yes.
There's been a lot of motion practice, so I think we probably got most of it covered already.
I think so too. That's just want you to take one more look at your file. So any motions are going to be due. Motions in limine, the 16th, August 16th. Response.
Is that 16 or 15, Judge?
16, which is a
Thank you.
Monday.
Yes.
Yep. So August 16th due, August 23rd responses. I'll see you back on August 30th.
Thank you, Judge.
Thank you, Honor.
Thank you. Take care.
Thank you, Judge.
Thank you.
Mr. Wood, that.
Your Honor, I have a quick question. Is Dalen Ware, is that on your docket today?
He is, yes.
All right.
And Your Honor, this is APA King. I'm on the Ware file whenever the court is ready.
Okay.
That is what you said next, right?
Huh?
That is what you said next, right?
Harvey.
Oh, Harvey.
Your Honor, this is Wyatt Harris. I'm wondered if Letitia Young is still on the docket and if she's going to be brought over. I've got to be leaving my location about 1 o'clock today.
Me too. So
I thought that's exactly what I thought you were going to say. I don't know why I thought that.
I'm gonna try to get her because I moved her over from last week. So I'm gonna
Correct. Yes.
else over. So I'll get to her. I'll request her, although there's been no mention of her yet, but I'll inquire about her. I have Mr. Harvey in the now. Ms. Taylor, are you with us? I know I lose the attorney sometimes. Mr. Cox, are you with us?
Yes, Judge, I'm here.
All right, Ms. Taylor, how about you?
Oh, there she go.
Oh, there she is. Okay. All right. Let's call Taylor. I mean.
Calling case 213849, people of the state of Michigan versus Lamont Harvey. This matter is set forth for a calendar conference today. Appearances, please.
Good afternoon, Your Honor. Kiefer Cox for the people, P79915.
Good afternoon, Your Honor. Alexandria Taylor appearing on behalf of the defendant, Mr. Harvey, P75271.
All right, and Mr. Harvey, good afternoon. Can you hear me?
Yes.
All right, Mr. Harvey, you are appearing today remotely via Zoom. I'm confirming you're okay with that instead of being present in the courtroom.
Yes.
All right, so Ms. Taylor, you asked for a DSU report, and I do have it. They brought it up to the courtroom right before the docket started. They tell us we can't send these because of the sensitive information.
Oh, okay.
I'll take the pertinent part, and then I'll have my law clerk, even after the docket, she can read everything else to you, okay?
Okay.
All right, so here's what it says in a nutshell. Present bond is $500,000, 10%. Case is police officer fleeing 4th degree. And he has an upcoming violation hearing scheduled before Judge Beal. It has his history, his employment, you know, Ms. Taylor, you know how this, everything that's in here, but the recommendation is it says his score is +3 on the risk assessment scale, which is average risk with under age 30, weapons offense and active probation outweighing full-time employment. However, pretrial services recognizes the assaultive nature of the allegations against Mr. Harvey. Maximum penalty potentially life with the A1 charge. It notes that he is currently on probation. It says, thus, pretrial services considers the present 500,000 10% bond reasonable and recommends no action to reduce the present bond. And so, in a nutshell. But again, I'll give this to my law clerk and she can go over it with you in more detail. So that is the recommendation. And I will say, and I didn't want to, pass judgment, and it's how I read the report, and I am of the opinion, I don't, just based on the nature of the charges and the fact that he's on probation, I can't find that the 500,000 10% is unreasonable in light of this capital offense. So that is where we stand in terms of bond. Mr. Cox?
Yes, Your Honor.
From the people's perspective, where are we as it pertains to this case?
So I spoke with my supervisor over the past couple of days, so we were able to gather an offer. So I don't know if you'd like me to put that on the record right now.
Yes, 1 second. Okay, I'm ready.
So the plea offer would be defendant pleads guilty to count 1, which is the AWIM, and count 4, which is the related felony firearm. We would dismiss the additional counts as well as the habitual notice, and it would have a sentence agreement of 8 years to 20 years for count 1, plus the 2 years for the count 4.
All right, Ms. Taylor, I don't know if you have a response. I don't expect you to have a response. I'm sure you want to think about it and talk to your client about it.
Right, Your Honor, this is my first time of hearing that. So I don't have a response right now because I need to go visit him and really have a discussion and review, the sentencing guidelines with him and where we think he would place. But if the court will allow, I just wanted to say one thing. I do understand the court's position with respect to bond, but I do want to add that my client was employed at AJM, which is a plant doing stacking plates in the automotive industry. Obviously, since he's been incarcerated for this length of time, he is no longer employed, but he was, and he was on HIDA for the fleeing and eluding case, which I'm going to be representing him on that violation before Judge Bill, and he had no violations prior to this case, and he was continuing his education and getting his GED, which was a condition of his probation. And lastly, I just want to add, at the preliminary exam, the alleged victim, his testimony was that he did not know who shot him. He did not see who shot him. And so this was, happened at a home, and there were multiple people there, and there was a lot going on. And so I just wanted to add that for the record, but I do understand the court's position.
Okay, all right, understood. Mr. Cox, is there anything you want to say in response?
I would slightly disagree with what the complaining witness testified to at the exam, but I'm happy to leave it at that. So nothing further from me.
Okay, all right. So, Madam Clerk, what's the date? I'm gonna give you, we'll just set a final conference, and if you want to come back sooner, so we'll set a final conference. I'll give motion cutoff. We'll check and see, has the transcript been filed, or do we need to check?
I don't believe I saw it on the register when I looked yesterday and saw the DSU. I didn't see the transcript on there.
We'll check, because that will impact the date that I give you.
Transcript says filed on 7/15.
Okay.
Okay.
And then what's the date for the motion cutoff for final conference? Like, what was the motion cutoff? Because this really is our calendar.
That's 29.
Yes.
So deadline would be September 9th for them to file.
So my motions will be due September 9th. Any responses? September 16th. In terms of your return date, I'll have to contact you with that, because my docket on the emergency docket only goes up to August 31st. So those are your cutoff dates, but the court will be in contact with you probably in the next week or so to schedule your return date for the final conference. Like I said, I can't guess as to what day and what docket I'll be on, and I don't want to just give you a random date to tie you up.
That's fine, Your Honor. Thank you so much.
Okay?
Thank you, Your Honor.
Bye-bye.
Bye.
Can you give me another one of these? Yeah. Ms. Jennings and Ms. Barnwell.
Yes, Your Honor.
You both are here. You still here? You're here on Haney, right? Both of you?
Yes. Yes.
Okay. So what I'm gonna do in the interest of time, I actually forgot about you. You were so polite about it. I'm gonna just put this over. And since I already know that we're still waiting on the competency report, then it's nothing for us to do. I'm gonna actually put this over, not to the 5th, but to the 16th, and see if we have an update. How many do I want?
The 16th of what, Your Honor?
August? Is that
No,
bad?
okay, Your Honor, I just want to make a quick record. I spoke to Jacqueline Sanchez, the acting director at the Forensic Center, and she said that Mr. Cheney would not even, Mr. Haney, excuse me, would not even be seen until sometime around the end of August, because the Wayne County Jail only schedules the defendants per day at 3 p.m. That is a very slow process. So I said, well, what do you actually think would be the day this report might be ready? She said, probably sometime towards the end of September. So I think it would just waste the court's time for us to come back before sometime in September.
So here's what I'm willing to do. I'm willing to bring you back on the 30th of August, push it out another 30 days to see if, in fact, if he's at least been interviewed. Because if he hasn't at that point, we may go to call and see if there's something, we can do about that. So I'm on the docket on August 30th. Docket C like Charles at 1 p.m. if that works for the two of you.
1 second, Your Honor. August.
Works for me.
Yes, works for me. Oh, no, the 30th. Okay, 31st, is that good, Your Honor, or no?
No, the 31st, I'm not on the docket. I'm only on the docket on the.
Okay. Okay, I have I have an appointment, but I'll make it work. And also, Your Honor, just briefly, you also scheduled Mr. Cheney on my case for a review date on the 26th. Is it possible to get that done on the 30th as well?
Absolutely, yes,
Okay, so I'll just put, they're gonna change it in the register of actions?
yes.
Okay, thank you.
So you not need to appear on the 26th. You just come on the 30th, okay?
Yes, thank you.
All right, thank you.
Mhm.
You said docket C as in cat?
Yes, ma'am.
Thank you.
Thank you.
Excuse me, Your Honor, what time did you say on that date?
1 o'clock.
Thank you, I'm sorry. Have a wonderful day.
All right.
Was that Larry King, the AP on that one?
The APA was Mr.
I heard my name. I'm sorry.
It was
I am
all
here.
good.
I'm here on where. That's the only matter I'm here on.
I don't know, because I didn't even call it. That's why. I can't think who it was. No, it's not Mr. King.
It's like, oh, maybe I'll.
I'm here on where also.
Right. All right. Mr. Lipscomb. Do we have Mr. Harris still? Lyle Harris.
Yes, Judge, I'm here.
All right. Have the prosecutor here?
It's Mr. Plymale. I don't know where he is, Judge, but we need another date. We're not going to do anything substantive with this case.
So yeah, I'm gonna put it over one more time, just till we get Mr. Plymale back, because we're gonna talk about final conference and finalizing everything for trial, so.
Right. Well, he has a second case that he hasn't even been bound over on, but it's only an FA. Okay, Judge, I got my calendar. What'd you have in mind?
Okay, so let's see, I'll make sure, let's go for the. Let me do it on the 16th. Of August.
We have 10 so far.
August 16th at 9
Oh.
a.m.
I have an exam at 10, but if we started it right at 9 or did it after my exam, I could do that morning.
We'll work it out. I mean, I know everybody's running into these conflicts, so.
Yeah, I know. So I'm sure, yeah, I'm not that heavy on the 16th. I just had that one other case.
Yeah, we'll work it out.
That's fine. I'll put it down for 9 o'clock.
Okay, thank you.
Okay, and Mr. Lipscomb, I'll be talking to you. Thank you, Judge.
All right. Oh, Mr. Ware is out. That's why I was confused. I forgot he is out.
He just recently got out on bond.
I know. No, you're right. Okay, Mr. Lipscomb, let them know you're all set, so I can get somebody else. Tell the deputy to come here first, to come to the microphone, please. Because I'm trying to get Ms. Young here. Do we have the prosecutor on Young?
Yes, Judge, that's me.
Oh, good. Okay. All right. And then I know we have to circle back to Coon. Mr. Ware, can you hear me?
Yes, I can. I can't hear you before.
Perfect. Yep, turn your camera on.
I'm trying to. My camera isn't working right now. I'm hitting. Start my video. There we go.
All right.
Could you see me?
Nope.
I'm hitting the start my video. I don't know what's going on with my camera. Hello? Can you still hear me?
I can hear you.
Yeah, I'm trying to put my. It seems not to working.
All right. Well, try.
This
And
is
I'll
the.
come back. Try. I'll come back to you, and if we have to wait here, it's because I think we may still be waiting on criminal responsibility at the end of the day. So.
That's correct, Judge. We are.
Okay. Did you call it?
I can try leave again.
Okay, leave and come back because he's actually out of custody. So if I run a few minutes over with him, that's fine. Okay, recall Coon.
I would waive his video appearance if you can hear everything the court's saying.
Okay.
You still want?
Yes.
Recalling case 214973. People of the state of Michigan versus Stephen Kuhn. This matter is set forth for tether violation. Appearances, please.
Noel, Rachel, for the people, Your Honor.
Rachel Jordan appearing on behalf of Stephen Kuhn was present.
All right. Okay. Ms. Ahoichi, were you able to find out anything else?
The exam APA judge says she didn't remember team wellness being a condition of bond, but at the end of the day, he still was trying to remove his tether. So I, without any explanation other than the obvious as to why he was doing that, I think it would be appropriate to increase his bond at this time.
Yeah. Okay. All right. So, like I said, I'll ignore the team wellness. Like I said, if the Jordan doesn't know and the prosecutor doesn't know, then there's no, I cannot connect the dots. But he really is no excuse for removing the tether. So I'm going to, I am going to increase his bond, and I'm going to put the tether back on. But maybe the increased bond will keep it straight. So it was 5,000 cash, 10%, and then it was, I guess, it dropped to personal.
Yeah, it was a personal.
Okay.
Let me get the exact one. It was $5,000 personal with GPS tether.
Okay. And at some point, Ms. Jordan, was it 5,000 cash with 10%?
Hello?
I believe the original bond was 5,000 cash, 10% with the GPS tether, yes.
Okay. So bond is going to be reset to 25,000 cash, 10% with GPS tether. And then this is before Judge Thomas. I'm going to give him an in custody date.
In custody for her.
Well, is she not back on there for a while?
Yeah, she's back on the 16th. Yes, D. Thomas is back on the 16th.
Okay, which doctor?
D. Dr. D.
Okay. Well, let me just ask you this, Ms. Jordan, can he make the bond? I mean, do you readily know, can he make, because that just determines whether or not I give him a in custody date or out of custody date for her.
You said it was 25,000, 10% or just cash?
25,000, 10%.
Can you make that, Mr. Coon? Shake your head, yes or no. He says yes.
Okay. So, yeah, he had a personal, so now it's going up to 25,000. So hopefully he gets the point that he can't just do what he wants to do. And I'm still putting the tether back on him. And so I'll give him a new date, Judge Thomas, on they said that she's on vacation.
I think she's back on the 16th.
Oh, so it's the same thing. Okay.
Yep.
Is that her? Well, she's on emergency docket. So
Oh, and then the
17th.
17th, I think it was, because she's Tuesdays.
Well, let me just do this. August 16th, the docket D. That's when she's on the emergency docket. If he doesn't make the bond, he'll already be in custody. If he makes it, he just logs in for that, Ms. Jordan.
On the 16th or the 17th?
The 16th, docket D like dog.
Okay.
And you're his lawyer on that case?
I am.
Okay.
And
So,
there's no provision for him to go back to team wellness or anything like that, correct?
I don't know anything about team wellness. No one can substantiate anything about team wellness, but when Judge Thomas, when he goes back before her, then she may, I mean, she clearly knows more. All I have is a tether report that no one knows anything about a condition. So yeah, from me right now, no, but I don't know what Judge Thomas is gonna do. Okay?
Okay, thank you.
All right, thank you. Bye-bye.
Good day.
All right. Mr. Crosby's in the chair. I'm trying to get, do I have a deputy? I'm trying to get somebody
For Division 1.
to get Miss Young.
I'm sorry, Your Honor, I was on the phone, but I am the prosecutor on Mr. Crosby. I haven't seen Mr. Upshaw today.
Because I don't know that we actually even, no. And actually, so he just had house counsel last time because Mr. Upshaw does not continue representation after sentencing. And so really, Mr. Crosby, and I think house counsel already left. I let him go back to the program. And so we already dealt with that. So I'm not sure we even need to do much today, or I can put this over again one more week to next week to see where we are with that. But we don't have house counsel anymore.
Yeah, I wasn't sure because typically I don't appear at, something past sentencing as well. I was just told last time it was to see if he had completed the program or at least had gone back to the program. Whatever the court wants to do, I'll obviously follow.
Okay, and yeah, I don't really know either. I guess he has his hand up. Let's unmute Mr. Crosby.
Yes, Your Honor. I'm not sure who my attorney is. I had a court appointment last time because Upshaw wasn't representing me anymore. But you set this for a review date. I just want to say that I have been back in the class and I have been, completing everything. I have a few days left. Well, 2 weeks left. I was just asking, could the courts consider me doing the class on the outside so I can return to society and be productive and just put this chapter behind me? I've been in here 4 months past what I was sentenced to. And, I'm just ready to just get back and do everything right, be there for my kids and reunite with my family.
Okay, so because again, it was Ms. Gabe Robinson, I think, was here with him last week. So, I guess the best thing to do would be to bring it back and next week and just to see, and it probably won't be her, but at least we'll have house counsel here to basically just verify that he is back and is doing what he's supposed to do, because I don't want to do that without him having an attorney here. So would you be available next week on the 5th?
Your Honor, let me check. On the 5th, yes, I am.
Okay, all right. So we'll put this matter over for the 5th. What's that?
D.
Docket D at 1 p.m. Docket D like dog.
All right, I will appear here then next Thursday at 1 o'clock.
Okay, thank you.
Thank you.
Bye. All right. Division 1.
Judge, is it possible we could squeeze Ware in? 'Cause I believe it's just,
Yeah.
I have a motion at 1 o'clock.
Yeah. 1 second.
Thank you.
And he's still trying to review. Call Ware.
Calling case 211202. People of the state of Michigan. This matter is set forth for final conference today. Appearances, please.
Good afternoon, Your Honor. Larry King for the people, P78774.
David Cripps appearing on behalf of Mr. Galen Ware. My bar number is 34972. No objection to Zoom.
I need you to mute Mr. Clark. Okay, Mr. Ware. Oh, Mr. Cripps already covered that. Okay, so according to my notes, Mr. Ware was referred for criminal responsibility on April 15th, I believe. So do we have a status, Mr. Cripps?
We don't have, I haven't received a report yet, Judge. And according to my client, I don't think he's been interviewed yet. So I can call the forensic center this afternoon and find out what the status, what the date they have for an interview.
Okay. All right. Mr. King, is there anything from you?
I've received nothing from the forensic center, no communications of any kind, Your Honor.
Okay. So I'll put this over. We'll see where we're at in another 30 days. Mr. Cripps, in the meantime, if you could call and get an update, because if we still don't have anything.
Yes, Your Honor, I will.
Beyond 90 days now, so I mean, the court may want to call and see if we can have a conversation with the parties to see where we're at, so. Okay, but for now, I'll just leave it with you, Mr. Cripps. Just call and see if you have an update and hopefully some progress, because it sounds like he hasn't even been scheduled. So, August 30th.
Thank you, Judge.
Let's see what time.
Let me just make sure that works. That works for me, yes.
Docket C like Charles at 1 p.m.
Very good. Thank you, Your Honor.
Thank you, Judge.
This was for where?
Yes.
You say he's not in custody?
Oh, you know what? I take that back. I'm still giving him an in custody. He was in custody, but he made the bond. So let's not tie up an in custody date. Let's do out of custody. So let's say, how many do I have on the 27th?
Judge, not August 27th. That's the one I have to move the 24th to.
Oh, okay. All right. So we are into either the 17th or the 20th.
Of August?
Yes. Just for status, just to see what Mr. Cripps is able to find out.
Either of those work.
Mr. Cripps, do you have a preference?
The 20th works better for me.
What time? We're still on the 20th.
10 o'clock, Judge.
What time?
Thank you.
10 a.m.
Okay. 10 a.m.
Very good.
10 o'clock.
Very good. We will see everyone then.
Thank you.
Thank you. Thank you, Judge. Have a great afternoon.
Thank you all. Bye.
Thank you, Mr. King.
Thank you, Your
Yeah.
Honor.
8:20 at 10 a.m.
Yeah. All right. Mr. Clark, can you get the deputy for me? I don't know what he's.
Your Honor, I'm here.
So can you have Miss, what's her name? Miss Young?
Miss Young is down on the 5th floor. I was on my way down there now. Do you still need her?
I need Miss Young, and actually, Mr. Clark, his lawyers are not here. I think that was, he probably should not have been on today's
Okay.
docket. I think I actually gave them a return date, but I thought that that wasn't until, hold on.
Okay.
Something, 1 second. What do you see for Mr. Clark?
All I got is 7:29.
Okay. It must be some disconnect because I wasn't really expecting him and the lawyers aren't here either. Let's put this over to next week. Let's put him over to the 5th. That could be like dog at 1 p.m. And then just bring Miss Young.
You just put over.
I didn't hear you. You broke up.
Who did you just put over?
Oh, and then you still have Mr. Carr, don't you?
Mm-hmm.
I need Carr and Young, and then that's it.
We gotta get Mr. still up there.
Yeah, for Carr. I'm not sure if he can hear me.
Okay. Okay, I'm back with you, Your Honor. Just the signals are weak in some spots in here.
Yeah, so did you get the new date for Mr. Clark?
Okay. Mr. Clark, you said you have a new date?
Let's just bring him back next Thursday to see what we're doing here.
Okay.
Down for docket D like dog at 1 p.m.
Okay.
And then I just need Miss Young and Mr. Carr, and then that's it.
Okay. I'm gonna run the tablet down there right now. It should give me about maybe 5 minutes.
And in terms of order, bring me Young, please.
Miss Young, okay. All
Thank
right.
you.
Just give me a few minutes. Thanks.
So while we're waiting on those last two, can you read that one for me? Yes.
Good afternoon, Your Honor. Did I miss a new date for Mr. Chad Haney?
8:30.
Yes, August 30th. That's gonna be, let me give you the docket. Docket C like Charles at 1 p.m.
Let's see. Okay, thank you very much. I'm sorry.
Okay, here, I just have a seat right here. Let's try to get the picture.
All right. Yeah, Young here.
Calling case 213587, people of the state of Michigan versus Letitia Young. This matter is set forth for final conference today. Appearances, please.
Noel Huishi for the people, Your Honor.
Mr. Harris, you're muted.
All this time. Good afternoon, Your Honor.
Oh, say it for me again. You cut out.
I know. Good afternoon, Your Honor. Wyatt. Someone's talking in the background where Miss Young.
You, Miss Young.
Okay. I'll start again, Your Honor. Wyatt Harris, 891 on behalf of Letitia Young, who in the Wayne County Jail.
Hold on 1 second. Oh, she's muted. Okay, now she's muted. Mr. Harris, now go. Third time the charm.
Okay. Wyatt Harris, P54891 on behalf of Young, who appears from the Wayne County Jail via Zoom.
All right, thank you. All right, so let's see. I think we were waiting. Well, let me ask Ms. Young. We need to unmute her so I can ask her that question. And then as soon as I get done, let's mute her again unless I need to ask her a question.
Okay.
All right, Ms. Young, you are appearing today with Mr. Stevens. I'm confirming you're okay with that instead of being present in the courtroom.
Yes, ma'am.
Okay, thank you. All right, and so I'm looking at my notes, and I think we were waiting on the transcripts. So, do you have the do we have the transcripts, Mr. Harris?
I do not.
They have been filed.
Okay. All right. Okay. So, I was waiting.
I sent an email for them, Your Honor, but I haven't received them.
Ms. Ahawashi, can you tell the date they were filed?
It's been a couple of weeks. I'd have to pull it up, Judge, on the ROA, but that's how I was able.
That's okay. I mean, I was thinking maybe you would say it was yesterday or something. So that's fine. So it should definitely show up that they're there. Okay. So having said that,
7/7 is the day it looks like.
okay, looks like July 7th that they were filed. And I wanted to make sure you had them before I gave you any type of motion cutoff and before I set a final conference. So I'm gonna give you a final conference date and a motion cutoff. All right.
Okay.
All right. So any motions are gonna be due. If this were the calendar conference, it would be the 9th. Is that right?
Mm-hmm.
Okay. So it's not really the calendar conference. Well, it's not the calendar conference, but let's say any motions due.
When is it?
August 23rd. Responses. August 30th. And then I'll have you back for our final conference on it's going to be determined. I don't have my calendar beyond for this docket beyond August 30th. So I'm gonna follow up with you on that date, but you have your motion dates. Okay, Mr. Harris?
Okay.
All right.
Okay, you said motions by when?
August 23rd. Responses?
By 8:30.
Yeah. And let's just put it in the system for, a review date or something on the 15th to prompt me. Don't listen to that date. You'll hear from me in the next week or two once I have my extended calendar for your return date.
Okay.
Just want to make sure I don't lose track of this. All right?
Okay.
All right, thank you.
Miss Young, I'll be setting up a media jail visit with you here. And then... Okay.
Your Honor, I'll be heading down 1 floor to get Mr. Carr.
All right, thank you.
You're welcome.
Your Honor, good afternoon. Will we be getting on the record with Mr. Carr today, or do you have time?
He's going to get him now.
Okay, I'm going to need time to go over the pre-sentence report with him.
Okay, you've been waiting patiently. We can do it, or we can push it to next week. So, I'm over my time, but they can just start with.
Yeah, no, I don't want to keep you, and I would rather not rush through with Mr. Carr.
Okay.
Judge, what I'd do is maybe we can put it on the record, and I'll coordinate a time with him not on the record, and I apologize. That's my fault. I should have done that beforehand. I thought we'd have a little more time today.
Okay, no problem. How many do I have on the 5th? And if need be, it could really even go to the 16th because he's right. Agent Petty, you're free to go unless you just want to stick around.
Thank you, Your Honor. See you guys tomorrow.
You should have 9 or 10 matters on the 5th.
Okay, so Mr. Whittier, you want to come back on the 5th next week?
Oh wait, excuse me. No, you have 13.
I thought it was more, so this will be okay, but it's still fine. Docket D at 1 o'clock.
On August 5, Thursday, August 5 at 1 p.m.?
Yes.
Perfect.
Docket D like dog. 1 week from today. All right, so when he gets here, we'll just put it on the record.
Thank you, Judge.
All right, thank you.
Okay, here's Mr. Carr.
All right, thank you. So this will be quick, just so you know, because we're gonna put it over, but we just want to put it on the record. So, okay.
Calling case 211552, people of the state of Michigan versus Lorenzo Carr. This matter set for sentencing. Appearances, please.
Good afternoon, Judge Joelle Hoishi for the people.
And Your Honor, good afternoon to you and also to your staff. Good afternoon. Michael Woodyard, P64612. I'm appearing on behalf of Mr. Lorenzo Carr. He's my client. He's on Zoom right now with us.
All right, very good. So what we discussed off the record, today was a date and time set for sentencing. As it stands right now, it is 1:11 p.m. and due to the state of emergency that we are operating under, my time on this docket was up at 1 p.m. And Mr. Woodyard, you indicated that today, again, we were set for sentencing, and Mr. Woodyard, you indicated that you still needed to go over the pre-sentence investigation report with your client. So you wouldn't have to rush, and you would be able to do that and take your time and go over that report, which is very important. You indicated it was your preference, and I think it does make the most sense to just put this matter over 1 week to allow you time to do that. Is that correct?
Judge, all of those statements are true and correct. Yes.
Okay. So docket B, like dog, 1 p.m. on August 5th.
Your Honor, that works with my schedule. That's great. Mr. Carr, I will Zoom meet with you and we'll go over this report. Okay, sir?
Okay.
All right, thank you.
Judge, thank you for your attention. Have a great day.
Mr. Woodyard.
Thanks, Your Honor. Have a good day.
Bye-bye, thank you.
Thanks.
Mr. Salad, are you here on Clark?
Good afternoon, Your Honor. I just finished up across the street. Would you like me to walk over?
No, so here's what, no. So I set this matter initially, we had our in-person evidentiary hearing.
Yes, we did.
And then I set this kind of as our next date, but then I decided that I wanted to take some additional, I wanted to hear from Ms. Frazier. I think you should have gotten that email. So we have a second date for our continuation of our in-person evidentiary hearing. It's not today.
Okay, that's what I thought. And I'll just double check unless Ms. Pierces can send me just an email so I can confirm that date. I do recall receiving and confirming my availability to continue the in-person evidentiary hearing.
And so when I didn't see anybody, because Mr. Clark did appear today, I just put him over to next week. But what I'm going to do now that you've appeared, and I'm going to just put him over to our evidentiary hearing, which is Rochelle, is that on the 17th?
It is August 17th at 1 p.m.
I'm going to change that to August 17th at 9 a.m.
Oh, wonderful. Judge, it looks like you're
Judge,
continuing
it's
to work
1
very
p.m.
hard. 1 p.m., Rochelle?
1 p.m.
Okay.
Okay. Thank you.
Thank you very much.
Take care.
Bye-bye.
All right, Ms. Ahoishi, I'll see you tomorrow.
See you tomorrow, Judge. Take care.
Bye-bye.
Thank you, Judge. That's it for today.
Ma'am, thank you so much.
Okay, thank